Barry, please find a seat. I want to get started. Okay. Good morning, everyone. Hope everyone who was at the gala last night had a good time. I would like to call up our color guard of the and for the national anthem. Gentlemen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Now I'd like to call to the podium Lieutenant Jessica Hernandez to sing the national anthem.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight, o'er the ramparts we watched, were so gallantly streaming, and rockets red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Please come to order. Good morning and welcome to the annual meeting of the New York State Bar Association. I would call for an approval of the minutes of our January 19, 2024 annual meeting. May I please have a motion? All in favor, please indicate by saying aye. Aye. All opposed, nay. Any abstentions? The motion carries. Thank you. I'd like to hear now from nominating report of the the report of the Nominating Committee of Election of Delegates to the House of Delegates by past President T. Andrew Brown, whom I believe is here remotely. Andrew?
Thank you, Mr. President. Good morning, colleagues. On behalf of the Nominating Committee, I submit the following nominations for elected delegates to the House of Delegates. For the 1st District, Stephen Charles Lazard, New York City. Susan Lindenauer, New York City. Kaylin Whittingham, New York City. For the 2nd District, Honorable Barry Kamens, Brooklyn. Pauline Young-Ha, Brooklyn. The Honorable Joanne Quinones, Brooklyn. From the 3rd District, Mara Afzazi, Albany. Hermes Fernandez, Albany. Colleen Pearson, Albany. From the 4th District, Cynthia Feathers, Saratoga Springs. Marty Onderdonk, Clifton Park. Connor Julius Real, Saratoga Springs. From the 5th District, Carl Mann, Herkimer. John McCann, Syracuse. The Honorable Jean Marie Westlake, East Syracuse. The 6th District, Alyssa Barrero, Binghamton. Jerry Ann Duvall, Cortland. Rachel Ellen Miller of Binghamton. From the 7th District, Eileen Buchholz, Rochester. Kimberly Fox DeGay, Lyons. And Langston McFadden of Rochester. From the 8th District, Sophie Thiel from Buffalo. Giovanna Macri from Buffalo. And Karen Nicholson from Buffalo. For the 9th District, David Evans Marcus, White Plains. John Papalardo, White Plains. Andrea Soto, White Plains. The 10th District, the Honorable John Leo from Central Islip. Peter Levy, Jericho. And Peter Mancuso, Mineola. For the 11th District, Alyssa Eisner, Forest Hills. Sharifa Melena Nasser Cuellar, Glen Oaks. And Arthur Terranova of Whitestone. For the 12th District, Michael Daly, the Bronx. Paul London, the Bronx. And Yana Roy of the Bronx. And for the 13th District, the Honorable Allison Hermangian, Staten Island. Catherine Schiavone, Staten Island. And Karen Soren of Staten Island. This concludes my report on behalf of the Nominating Committee.
Thank you very much, Andrew. May I have a motion to approve the nomination to the members of the House of Delegates?
Mr. President, I move to close the nominations.
Thank you, sir. By acclamation, may I have a motion? All in favor, please indicate by saying aye. Aye. Any opposed, nay? Any abstentions? The motion carries. Thank you, Mr. President, past President Andrew, and good friend. Unanimously, may I add. We will now hear from our Treasurer, Susan Harper. Report of the Treasurer. Susan.
Hello? Okay. Good morning, all. It's a pleasure to be here with you today. I will be reporting on the annual meeting and the gala, our building renovations update, the performance of our investment accounts end of the year, and changes to our membership renewal from calendar to anniversary, and how that will impact our future financial statements. We're still working on our end of the year 2024 financial statements, and we're awaiting post-retirement actuary report. So therefore, we'll be reporting on audited numbers in April. But let's get started. So I am excited to share that the annual meeting this year brought in over together 3,000 people. It's been so nice to see so many faces again and to engage in discussion. In my role, I'd like to touch upon the numbers. This year, our annual meeting general registration tickets sold to amount of over $1.1 million compared to last year of just $1 million. And I am delighted to share that we were ahead by $166,000 this year. As we're all aware, the costs of holding meetings of this size are significant, and we continue to research and to discuss options to bring down costs and work with association leaders and our membership to consider and review the possibilities. Now I want to turn to the gala. So it was a pleasure to spend the night in your company at our wonderful gala last night. As you know, the gala event was sold out with over 500 attendees registered. On the sponsorship end, we had 28 total table sponsorships and 13 sections contributed to sponsorship. This year, we anticipate a slight deficit of approximately $25,000 due to a shortened meeting our sponsorship table sales. Next year, we'll be celebrating our 150th anniversary, and we will be seeking greater corporate sponsorship to participate in this historic event. We want this to continue to be the who's who of who's in law, so the gala team is reviewing ticket costs as well as sponsorship packages to encourage maximum participation and to ensure that we are at break even and to generate revenue for the association. I want to thank our gala team led by Gerard McAvery and John Gross for the team's fabulous work, and thank you for your leadership. Let's give them a round of applause because this was an enormous job. We're just going to talk a little bit about section revenue and expenses as of December 2024. As we don't have audited financial statements yet for 2024, please keep in mind that these are not final numbers, but I want to just quickly touch upon just sections and where we stand 2024 year end. Our sections continue to work very hard for their section members and have put on outstanding virtual and online programming in 2024. We are seeing, however, a combined unaudited loss of $219,000 as of December 31st, 2024, and a combined budget and revenue expenses not met. In 2024, we had 14 destination meetings. We went to Sonoma, California, Saratoga Springs, Boston, Montreal, Vermont, South Korea, just to name a few. All combined, the sections, we were behind by $185,000 on destination meetings, meaning 84% of those total combined losses that I just mentioned before are just from destination meetings alone. So to be proactive, to support our sections, and to help close this gap, we have been, and when I mean we, it means our internal staff, our finance committee, myself, and the finance office. We are meeting with various sections on a one-on-one. We have been discussing the section's financial policy with the different sections who are having the destination meetings. We have been reviewing meeting registration numbers, sponsorship, and any last-minute requests that may end up in expenses. We have been emphasizing starting planning destination meetings early that might prevent any last-minute requests. We have also been debriefing following destination meetings to learn and understand what we can do better. I want to thank our sections for all their hard work and their efforts. Being a former section chair myself, I want to thank you for continuing to work with us to address these issues and to help us and help you meet your section meeting financial goals, and so that our New York State Bar members have the best experience possible. So now we're going to move to the new membership model update. Since going live with the new membership model on September 15, 2024, we were able to renew and engage 35,000 members. In terms of sales, as of January 9th, we have received $8.3 million, out of which 486,000 are new joins and rejoins. As of December 31st, 2024, the financial position shows that we are deferred at $7.6 million compared to 2023 deferral of $5.9 million, and we're ahead by $1.6 million. So these are very promising results. Yes, please applause. These are very promising results of the new membership model. I want to congratulate the entire team, Pam and Pat heading up membership marketing, and Tony and his IT team, and just everybody who has worked so hard on this, and all our membership chairs from previous and to date. Thank you so much. So now we're going to move on to the building renovations update, and this is such wonderful news. The renovations to our bar center at One Elk are complete. The renovation work was completed on time and within budget. We are very grateful for the attention of our leadership and the finance committee to complete this important project. We're very appreciative of the work of Turner Construction, our project manager, Alan Gershovich. Our historic long-term home is now improved for our members and staff, and we encourage our sections and our committees to consider holding meetings and programs at the Bar Center this year and in the future. So special thank you, very special thank you, and I want to hear an applause at the end here. Special thank you to Dave Miranda for his very important role and his guidance during this important project. We appreciate your efforts immensely, and to the Finance Committee, led by Michael McNamara, and the New York State Bar's Finance Office, led by Amir Rizvanovich, and previously Chris O'Brien, for their multi-year work on this project. Now, this is officially complete. I want to round up the year with our investment accounts and where we landed. In 2024, as you've heard, we had significant expenses between the building renovations, marketing efforts for our new membership model, as well as technology upgrades. We spent over $5.6 million on these three very important projects, capital projects. We had funds earmarked for the buildings, including a replacement reserve, as well as funds received from the PPP loan. I want to show you where we're currently at with our investments as of December 30, you can see up on there on the screen, December 31, 2024. As you can see on the screen, we're very fortunate to increase our portfolio while paying some of these high-value expenses. With the steady hand of our Finance Committee, our Investment Committee, as well as our capable investment advisors, working together, we were able to pay all the expenses while also increasing our investment portfolio. So I want to thank you very much, and to the dedication and guidance to all of those members who I'd mentioned. For right now at this time, at the end of the year, December 2024, our portfolio now is $60.1 million, and compare that to 2019, our portfolio has grown 28.4%. So that's incredible. That's really, really great return. So not only do I want to thank the current team, I really want to thank all the past team members too, because all the work that we do at the New York State Bar over 150 years, we build upon each other. We build upon each president. We build upon each committee. So I want to thank you all. And last, let me just talk to you a little about the changes and the impact of our financial reports that you will be looking at. As we know, we change our membership renewals from a calendar to the anniversary renewals going forward. And these changes carry very different recognition rules and will impact what the financial statements look like that you will be receiving going forward. Changes to the anniversary renewals will have dues being recognized all year long and not just upfront in January as we're used to seeing. So cash will be coming in throughout the year and depends on the anniversary date when the member signs up. So this will improve our cash flow, especially during the summer months, which it's always been a challenge then. So with these changes, the year-to-year comparison will look different and will take at least a year to have good comparable numbers. Section financial reports will not be impacted, as sections will continue to get their royalty payments in the first quarter of the year. No changes are anticipated there. In April, our next meeting, we will have our audited 2024 financial statements, and we will be able to accurately indicate the 2024 year-end numbers. This concludes my January 2024 Treasurer's Report, and I welcome your questions, and thank you for your attention today.
Susan, thank you very much for that excellent report. It is accepted with the thanks of the association. Now call upon Robert Schofield, Chairperson of the Committee on Bylaws, for the report of recommendation of the committee. Robert.
Good morning, Mr. President. Good morning, everyone. Good morning. This is the moment that we've all eagerly anticipated all week. I frankly wish I was involved in the trial program this morning. In the event that there are people in the room that aren't fully read in as to what's going on and where we are, let me just give a bit of an overview. First of all, the stated purpose of the Committee on the Bylaws is to examine and report on proposed amendments to the bylaws of the association and to observe the activities of the association under the present bylaws, and from time to time report to the Executive Committee and the House on changes and amendments that, in its opinion, will promote the efficiency of the association. This report did just that. In June of 2024, the House adopted the report of the Strategic Planning Committee, and one of the prongs of the Strategic Planning Committee report was a charge to the Bylaws Committee to do a comprehensive review of whether or not the bylaws of the association as currently written were in full compliance with the not-for-profit corporation law and its many amendments over the last several years. That is the review that we undertook. At the House meeting in November, we presented our report to the House, explaining the changes that we were proposing to bring the association into greater compliance with the not-for-profit corporation law as it's currently written, and we proposed a series of amendments to do that. The most significant portion of the report was a change to have the House of Delegates, which is currently serving as the board of the organization, turn that role over to the Executive Committee based on a number of factors, which were outlined in the report, but essentially which were concerns about our ability to continue to comply with the NFPCL if we maintained the House as the board, concerns about the awareness of the 250 members of the House regarding their fiduciary obligations, that they were indeed serving as directors and trustees of the association, concerns that because the House was the nominal board under our bylaws, that we were not complying with provisions of the not-for-profit corporation law with respect to reporting obligations that we had, and general concerns that while the House was described as the board in the bylaws, it had never functioned in that role, and that essentially other entities, including the Finance Committee, the Executive Committee, and the elected officers, were piecemeal functioning in various capacities to fill the role of the board. Because of that, the Bylaws Committee made a surgical decision to take the words in the bylaws that made the House the board and make the Executive Committee the official board of the organization, so that we had a governance structure that more correctly reflected the NFPCL and more correctly reflected the factual situation in our association. So that report was presented in November. It was subscribed by the House. I know there were some questions about what the required subscription was. I heard yesterday that the numbers were somewhere in the order of 12 or 13 in excess of the subscription amount, although I didn't hear what the attendance at the House meeting was in November. So they are properly before the association membership here today. Since then, we received a thoughtful letter from several past presidents that explained concerns that they had about that change, and specifically the change of the board status from the House to the Executive Committee. I think that they have raised many of the issues that the Bylaws Committee considered in looking at the issues. I think that they have focused on some items that can be addressed in other ways, but ultimately it is clear that the issues that they raise are the core issues of this decision. And ultimately, while the Bylaws Committee fully believes that this report that we've put forward is correct, and it has the endorsement of the Executive Committee and also the subscription of the House, we recognize that this is a fundamental issue. And if there is a situation that there are groups of people within the association believing that we need to do more to study this, we're ready to do that. So I understand that there may be a discussion on a procedural issue this morning. I don't want to say a whole lot more about where we are. I could go on ad nauseum as to why it is that we think that the changes that we've presented are appropriate, but I will also tell you the Bylaws Committee is ready, willing, and able to continue to study the issue and see if we can find an approach that brings all of us into an alignment as to how we go forward.
Thank you, Robert. Mr. Younger, past President Steve Younger, I believe you have a motion, sir?
And thank you, Mr. President, and thank you to you for your leadership of this association. Thank you to Mr. Schofield for making bylaws so interesting.
My pleasure.
Before I forget, Steve, you have now 2 minutes and 50 seconds.
You're welcome.
How much for my leadership now?
Now, I speak on behalf of 17 past presidents who wrote a letter that's in your materials opposing these bylaws changes. I understand this morning the section caucus voted to oppose them. I've heard from various bar leaders that doing the same thing. We believe that it's not wise to shift the governance powers that this body has historically handled from the 250-member House to a 24-member executive committee, which would be less representative of our association. This has worked well for 50 years, and there's no reason to change it. I just want to give a little bit of history. It was 5 decades ago that we had a governing body like it's being proposed now. It wasn't representative of the state, so our forefathers said, let's create a House of Delegates so all of us can take part in governance. I want to make clear there was, a reference to complying with the nonprofit law. The shift from the House to the Executive Committee is not, let me say it again, is not required by the nonprofit law, and I think the Bylaws Committee agrees with us on that point. I want to talk about leadership development. Many of us came here representing sections, representing local bars. We want to take part in governance, and that's what this body has done for a long time, and it should continue to do. I just want you to focus on our treasurer's report this morning. She said we finished our building campaign on time, on budget. That was a decision made by this House, and I think those are the kinds of decisions that this House should continue to make. So we have 2 things we would like to have studied. The only compliance issue that we're out of compliance on in terms of governance is our Finance Committee is not a member of the House. It should be made a member of the House, and we ask you to look at that. Second, in terms of day-to-day oversight of management, that's in the House right now. That doesn't make much sense. There was talk under Glenn Lauke's special committee of forming a special committee of the officers, or maybe the officers plus the Finance Committee chair. That's what should be done to oversee management. The Executive Committee meets 4 times a year. They're not the proper body to do that.
Steve, you have 20 seconds.
Yeah. So I'd like to move, with the unanimous support of the section caucus, with the leadership of 17 bar presidents, that the proposal on the table be tabled to the next annual meeting. Thank you so much.
Steve, would you want to add that the next annual meeting can be called as a special meeting?
Have no objection to that.
Thank you, sir. The motion to table is non-debatable.
Mr. President, can I just clarify one thing? I think we're all saying the same thing, but we're using the term annual meeting, and I think we need to say the next
The
association.
next association meeting, not the House meeting.
That's fine, Mr. President.
Thank you. So once again, the motion has been made, it's been seconded, it's non-debatable. All those in favor of past President Younger's motion to table the issue, please indicate by saying aye. Aye. Those opposed by saying nay.
Nay.
Any abstentions? The motion carries. The matter is tabled. I'm sorry. The online, I'm sorry, you're right. We're good? The motion carries. Thank you very much. Thank you, past President Younger. And thank you, Bob.
Mr. President, may I just make one observation? And unless there be any question about this, sometimes we get heated in our debates and we are passionate about our positions. I certainly have been accused of that with respect to moving this forward. But I want this body to know You've entrusted this process to the Bylaws Committee, and there is no group of people that are more genuinely focused on doing what is right for the association, for thinking through these issues and for studying them. We have experts among us. We have people with long tenured service to the association among us. We have new members among us. And I just want to make sure that everyone knows that this committee really does believe in its work and has worked very, very hard on both this report and the materials that it's presented to you previously.
The agenda for the annual meeting is now, well, may I have a motion to adjourn?
So moved.
All those, second, all those in favor indicate by saying aye. Aye. All those opposed, nay. Are there any abstentions? I can't imagine that the people online are going to say we want to continue, so I'm going to take it for granted they said they don't. I would like to call up the Honorable Cheryl Chambers, President of our New York State Bar Foundation. Judge.
Thank you. Good morning, everyone. Oh, you got to say it louder than that. Good morning, everyone. So I'm going to take a tip from Mr. Schofield, having served as the Bylaws Chair for over 7 years. I am glad that I'm not him. I am Cheryl Chambers, President of the New York Bar Foundation. You, the members of the House of Delegates, are also members of the Foundation, and that's why we conduct our business meeting immediately after the association's annual meeting. And as Henry VIII said to Anne Boleyn, I won't be keeping you long. I call to order the meeting of the Foundation. The first item of business is the approval of the minutes of the annual meeting of the Foundation on January 19th, 2024. The minutes have been distributed online to all members of the House of Delegates. Are there any corrections to the minutes? If not, may I have a motion to approve the minutes as distributed? All those in favor? Aye. Anyone opposed? Any abstentions? The motion carries. The minutes are approved. The second item of business is to ratify and confirm the actions of the Board of Directors since the 2024 annual meeting. May I have a motion? Is there a thank you. All those in favor, please say aye. Aye. Anyone opposed, please say nay. Any abstentions? Thank you for that ratification. As you know, the Foundation has been strategically investing in ideas, individuals, dynamic organizations, and impactful institutions. These investments enable us to address justice issues and identify effective grant-making solutions across New York State, ultimately driving positive change. Our scholarship and fellowship program provides future lawyers with education and hands-on experience. In 2024, we awarded $848,966 in grants, fellowships, and scholarships. I said $848,966 in grants, fellowships, and scholarships. To showcase the incredible impact of your contributions, the foundation, I'd like to share a short video with you. In 2024, the Foundation awarded a grant to the Rochester Legal Aid Society. In the video, Mark Moyo, Program Director of the Housing Unit of the Legal Aid Society, will explain how the Foundation's investment in the Tenant Defense Project has made a significant difference for his clients facing eviction. We can play the video.
The Legal Aid Society is a not-for-profit law firm in Rochester, New York, in Monroe County. Our mission is to serve low and middle-income families and their civil legal services needs. Our work in eviction prevention is mainly in Rochester City Court, where the Legal Aid Society has a presence at every intake, first appearance, and where we offer representation to anyone facing eviction in the city of Rochester. We're able to do that through the funds that we receive from the foundation, as well as from state and federal grants that we receive. And we've been able to do that since the beginning of the pandemic. Before the pandemic, before this type of investment, representation was about 10 to 15% of tenants facing eviction in city court. And we've brought that well over 50%, probably in the 65 to 70% range. In terms of raw numbers, that's approximately 100 individuals a month, well over 1,000 per year. Demographics of that, largely women and largely women of color. And most of those women have children that they care for. Our goals are our client's goals. So if a client tells me that they'd like to stay in the property, then I pursue that with full force. If they tell me that they'd like to move and they give me a timeline for that, I reach a little further to make sure that they can move as gracefully as possible, knowing that the world has a lot of variables in it in terms of moving, paying for movers, and finding a new place to move to. Of course, we can't meet that need unless we have significant attorney presence there, and of course that takes money to pay salaries and benefits. So the investment that the foundation has made has helped us maintain staff and to train new staff to do this work and continue offering this representation to folks facing eviction. And I'd like to, on behalf of the Legal Aid Society, thank the foundation for its investment. It's had a tremendous impact on the people facing eviction in our community and on our ability to practice on their behalf.
So since the launch of the Tenant Defense Project, several positive outcomes have been observed. One, the tenants have better access to legal representation and support. With legal assistance, tenants are more informed about their rights and legal processes involved in eviction, empowering them to make informed decisions leading to improved housing stability. And three, your contributions strengthens the capacity of the Rochester Legal Aid Society to provide timely and effective assistance to those in need. These outcomes highlight the project's success in providing crucial support to vulnerable tenants and underscore the importance of the foundation's partnerships and continued investment in these types of initiatives. The officers and the directors of the foundation are committed to strategically investing your contributions to maximize the impact of our collective philanthropic efforts. The next item on the agenda is the report of the Nominating Committee. I will call on David Shraver, the Vice President of the Foundation, to give the nominating report via video conference.
Good morning, everyone. I have the privilege of reporting on behalf of the Nominating Committee of the Foundation. The following individuals have been nominated to serve as members of the Foundation Board of Directors for a 3-year term commencing June 1, 2025. They are Ross Cartez of Rockville Center, Sherry Levin Wallach, Pound Ridge, John Nona, White Plains, Kimberly Wolf Price, Syracuse, and M. Salman Ravala of New York City. And the following individuals have been nominated as incumbent directors of the Foundation to begin their next 3-year term commencing June 1, 2025. They are John P. Christopher of Delray Beach, Florida, and David Singer of New York City. I move the election of these directors.
Is there a second? Are there any questions? Hearing none, all those in favor? Aye. Any opposed? Abstentions? The directors are duly elected.
For informational purposes, I would also like to report that the Nominating Committee has recommended the following persons to serve as officers for a 1-year term to commence on June 1, 2025. They are the Honorable Cheryl E. Chambers, President, James Kobach, Vice President, William T. Russell, Jr., Treasurer, Ellen McCoskey, Assistant Treasurer, Pamela McDevitt, Secretary, Lucia Wisenand, Assistant Secretary, and Susan Lindenauer, Chief Publicity Officer. Officers will be elected by the board at its upcoming annual meeting. That concludes my report.
Thank you, Mr. Shraver. In closing, I'm pleased to announce that the New York Bar Foundation will celebrate its 75th, oops, did I do something wrong? I did. He made a motion, you seconded, we voted? Yes, we did. Okay. We were up to the informational purposes. In closing, I am pleased to announce the New York Bar Foundation will celebrate its 75th anniversary at its Force for Justice Gala on November 7th, 2025 at 6:30 p.m. at Gotham Hall in New York City. Please save the date. We assure you, you will have a very enjoyable evening, and unlike our cocktail party, we're starting a lot earlier. If there's no further business, I will entertain a motion to adjourn.
So moved.
Okay, the ayes have it. I want to thank our foundation staff, Executive Director Deb Elspelmeyer and Program Coordinator Lee Dorr for their hard work and dedication. That ends my report.
Good morning.
Good morning.
With no palate cleanser, we're going to move right into the House of Delegates meeting. Welcome to the January 2025 meeting of the House of Delegates. This is a hybrid meeting. We are joined by our colleagues virtually from across the state and around the world. Our thoughts today are also with our colleagues in Los Angeles, their families, clients, and communities in light of the catastrophic losses there. I'd like to remind you that this meeting is being recorded. The recording will be posted online and will be available to the members of the association, members of the public, and the media. A reminder that materials are now posted to the House of Delegates webpage. Any supplemental materials that were submitted late have been posted to that page. If you've not already done so, please complete the attendance cards that are at your seats. Turn them into the staff at the registration desk at the end of the meeting, as this is our procedure for taking attendance. For our remote attendees, attendance is recorded via Zoom. So please ensure that your full name is displayed in Zoom so that your attendance can be properly recorded. I would also like to remind our delegates who are participating via Zoom on the mechanics of remote participation in the meeting. First, for reports on which discussion and votes are required, please use the raise hand feature after the presentation of the report to be recognized should you wish to request to speak. Second, after discussion is completed, you will be asked to complete a poll that will appear on your Zoom screen. You will select aye, nay, or abstain, and then you will click submit. You will have 20 seconds to vote. The vote results will be displayed on your screen. Third, if you abstain from a vote, please send an email to Melissa O'Clair at moclair@nysba.org so that your abstention can be recorded in the minutes. If you're attending the meeting in person, please use the standing microphones should you wish to speak to a report. For any items that require a vote, the voice vote in the room will occur simultaneously with the launch and closing of the online poll. Please note that there will be a short delay to allow the in-person and online votes to be tallied. For all delegates, both those participating remotely and those here in person, if selected to speak, as has been our practice, we ask that you follow these guidelines to promote an orderly discussion and debate. Delegates should identify themselves and their affiliations. Delegates should speak only once and limit remarks to 3 minutes. If I notify you that your time has expired, Please wrap up your remarks. My comments are not a reflection on your position, but rather my responsibility to ensure that all members participate fairly in the discussion. Any questions to a presenter or otherwise should be directed to me as chair of the House. Delegates should refrain from procedural motions until all substantive discussion is completed. In this regard, a delegate may rise to speak to the motion on the floor and advise me that they intend to make a procedural motion at the appropriate time. I will recognize you to make that motion. All presenters and delegates rising to speak will be treated with collegiality and respect by all members of this House. We will now proceed with the meeting. The first item is the approval of the minutes of the November 2nd, 2024 House of Delegates meeting. Unless there are any corrections, amendments, or objections, the minutes of the meeting will be accepted as distributed. There is no vote necessary unless there is an objection. So, hearing no objections, the minutes are approved. Next up, the report and recommendations of the Nominating Committee and election of officers and members at large of the Executive Committee, past President T. Andrew Brown. The request.
Thank you, Madam Chair.
I have a little more to say, Andrew.
I'm sorry, Madam Chair.
It's okay. That pause was a trap. I'm sorry. Article 11 of the bylaws requires that the elected delegates to the House of Delegates shall be elected at the annual meeting. The number of such delegates is fixed at 3 from each judicial district by Article 5, Section 3 of the bylaws. The Nominating Committee has filed a report containing the requisite nominations. The list of candidates for the office of elected delegates from each of the 13 judicial districts has been distributed to House members. Past President T. Andrew Brown will be presenting the report.
Thank you, Madam Chair. I'm sorry that I cannot be with you in person this morning. On behalf of the Nominating Committee, I would like to submit nominations for officers and members at large of the Executive Committee. These nominations were made in compliance with association procedures. Beginning in June, we issued requests for candidate applications to all NYSBA members. During the fall, we evaluated candidates' applications. In September and November, we interviewed the candidates at meetings. In November, we voted on the candidates and prepared our committee's report. Thank you to the Nominating Committee for its efforts and to the candidates for their participation in this important process. I would now like to submit the following nominations for officers and members at large of the Executive Committee. President-elect Taya Grays of New York City. Secretary Thomas Maroney of New York City. Treasurer Susan Harper of New Jersey. District Vice Presidents for the 1st District, Adrienne Beth Koch of New York City, Diana Sen of New York City. For the 2nd District, Amy Richter of Brooklyn. For the 3rd District, Jane Bellow Burke of Albany. For the 4th District, Michelle Wildgrube, Schenectady. For the 5th District, the Honorable James Murphy of Syracuse. For the 6th District, Dawn Joyce Lanuette of Binghamton. For the 7th District, John Getz of Rochester. For the 8th District, Norman Effman of Warsaw. For the 9th District, the Honorable Karen Beltran of Yonkers. For the 10th District, Justin Block of Sayville. For the 11th District, Frank Bruno of Glendale. For the 12th District, Hugh Campbell of the Bronx. For the 13th District, Sheila McGinn of Staten Island. Executive Committee members at large: Ann LaBarbera of New York for the Young Lawyers seat. Ellen Makovsky of Garden City for the section seat. Nick Rangel of Albany, the Honorable Adam Seiden of Mount Vernon, and Vivian Wesson of Pennsylvania for the diversity seat. Madam Chair, this concludes my report on behalf of the Nominating Committee.
Thank you. Is there a motion to close the nominations?
Madam,
All in favor?
I move to close the nominations.
Do I have a second? All in favor? Aye. Any opposed? Any abstentions? We'll check the vote. Motion carries. Is there a motion that a single unanimous ballot be cast by the Secretary for the election of the delegates?
Madam Chair, as a member of the House, I move that a single unanimous ballot be cast by the Secretary for the election of officers and for the Executive Committee members at large.
Thank you. And we have a second. All in favor? Aye. Any opposed? Waiting for our online colleagues. We're all good. Thank you very much, Andrew, and congratulations to the elected delegates.
Thank you.
Our next item is a report of the Task Force on Opioid Addiction. Dr. Mary Beth Quaranta Morrissey. This is an informational report.
Thank you, Madam Chair, and good morning. Good to see everybody. Permit me to open my remarks by acknowledging the vision and leadership of our President, Domenick Napoletano, in creating this task force. It has been my honor and pleasure to serve as chair. We have a simply wonderful task force with members from all sectors, including New York City prosecutor offices, as well as public defenders from across the state, and social services providers. So let me begin by spending a few minutes on what we've been doing. We've spent a great deal of time, importantly, framing the problem of substance use in its full complexity. And that includes, of course, access to treatment and services, workforce development and expansion, funding for treatment and services and to support the workforce, settlement fund distribution, and also we've heard very moving testimonies from task force members about their experience of vicarious trauma in the delivery of services to those who are needing substance use treatment and services. We've also discussed the balancing of risk to communities, meeting those who are struggling, meeting the needs of those struggling with substance use and addiction, the need to expand treatment programs and services to meet those needs. And, at the top of the list is more funding for these needs. We've also spoken and discussed the needs of certain special populations, including persons in carceral settings, older adults, pregnant women, mothers, and children. We would like to bring to your attention that there is an excellent paradigm in Staten Island under the Staten Island District Attorney. We do have someone from that office on our task force. They have what is regarded as the most successful program in the state. We do have some excellent information from that office about the program, and the health law section, parenthetically, is working with Staten Island on an 1115 waiver program. So we will be building on that work and hope to create a borough-wide CLE program on opioid addiction as we move forward with this work. So that concludes my report, and happy to answer any questions.
Do we have any questions from our online colleagues?
Right, hearing none. Thank you so much for your time today.
Thank you, Mary Beth. Your report is received with the thanks of the House. Next is the report and recommendations of the Task Force on Homelessness and the Law, William Russell and Meredith Dodd. The requested action on this is approval of the report, and you should know that at its meeting yesterday, the Executive Committee endorsed the report.
Thank you. Good morning, everyone. For those of you who don't know me, I'm Bill Russell. I'm a partner at Simpson Thacher here in New York. So on behalf of New York City, for those of you from outside the city, welcome to New York this week. I want to start off with 3 apologies, 2 of which are kind of contradictory. The first is I apologize on behalf of my colleague Meredith Dodd. She's unable to be here. She had a client emergency, but she played a really instrumental role in pulling together this report. The other 2 somewhat contradictory apologies are as follows. First of all, I want to apologize for the length of the report. It's 108 single-spaced pages. So for those of you who've read it in its entirety, thank you for your patience. And it is worth a read, but it is a long report. The second apology that is somewhat at odds with that one is, despite the length, it is still really a superficial treatment of what is an extraordinarily complex set of issues. It really just scratches the surface. We have a number of recommendations, and there's a lot of information in the report. But again, this is a very complicated set of issues, and it could be very easily have been a 1,000-page report. So I'd encourage you, if as you hear this presentation, as you read the report, if there are areas of particular interest to you into which we don't go into sufficient depth, look at the footnotes. There's a variety of firsthand sources there, and you can get additional information by looking at the notes and all the other materials we cite. So the task force was appointed back in June of 2003 by immediate past President Dick Lewis. It was an issue of great personal importance to Dick, and one of the things Dick very much wanted to achieve in connection with his term as State Bar President was to bring together subject matter experts to develop legal policies and strategies to improve this tragic situation in New York and throughout the country. Actually, throughout the world. I was in Dublin last year and saw a large number of street homeless rivaling the ones we see on the large cities in the U.S. So here's the mission statement. I won't read it. You can read it for yourselves. But in essence, we were directed to look for policy and legal recommendations to reduce the number of individuals who are experiencing homelessness and to improve the lives of individuals who, regardless of our best efforts, continue to experience homelessness. So let me talk a little bit about the scope of the problem. It really should be evident to anyone in the state, anyone who walks through our cities or drives through the rural or suburban areas. Every year, Housing and Urban Development releases what they call a point-in-time estimation, where they go out and they try and count the number of people living in shelters and the number of street homelessness. So in 2023, they estimated that there were 90,000 individuals experiencing homelessness in New York State. This was approximately 15% of the nation's homeless population. HUD recently released their figures for 2024. It was too late to incorporate them in this report, but they're staggering. The number has gone up in New York State to 158,000. That's a 53% increase over last year. And some of this is obviously attributable to the large number of new arrivals in the state seeking asylum, but that is not responsible for all of that increase. And another thing to remember is these numbers that we're talking about are generally recognized to be a significant undercount for a number of reasons. One, the point-in-time analysis obviously can't capture everyone. And secondly, it only captures people living in shelters and people on the street, and it doesn't capture people who are homeless who, for example, are living in their car or sleeping on a friend's couch. So while these numbers are staggering, they are, in fact, an undercount. And it's, as I mentioned, it's not just an urban problem like a lot of people think. There is a large number of people experiencing homelessness in our suburban and rural communities as well. The problem isn't getting better. It's getting much worse. As I noted, there was a 53% increase in New York State alone. You may have seen articles in the in the New York Times and the Wall Street Journal about the nationwide HUD count. The most recent data is that there were 771,480 individuals in the U.S. experiencing homelessness. That's an 18% increase over 2023 and the highest number ever recorded in the U.S. New York City alone had more than 4,100 people living on the street last year. There's a New York Times article about that. And that's, again, the highest number since the city began keeping count. Causes of homelessness. There are frequently multiple reasons why any one particular individual is experiencing homelessness or is housing insecure. Contrary to common belief, most homelessness is not the result of substance abuse or mental illness, although those can obviously be among the various causal factors. Most homelessness and housing insecurity is a result of a combination of factors, but the leading factor, the most important factor, really is a lack of affordable housing. Other factors are the various barriers that exist to people who are trying to access the affordable housing that does exist: low wages, unemployment, lack of affordable health care, and domestic violence issues. Individuals living on the margins of our society are often just a lost job, a lost wage earner from a household, a rent increase, or an unexpected medical bill from becoming homeless. So, as I mentioned, Dick asked us to take on this task. We put together a task force. We want to, particularly given the breadth of the issues, we want to look at the situation from a variety of perspectives. So we recruited some really terrific task force members. As I said, this is a long report, and it was truly a group effort. We had a terrific group of people. We represented the geographic diversity of the state. We had people from all the major cities. We had people from suburban areas, rural areas. If we could move to the next slide. Thanks. We had current and former municipal government employees, academics with relevant research, practical and teaching experience, representatives of a host of legal services organizations and other nonprofits who address the needs of the homeless and the housing insecure on a daily basis. Lawyers like myself in private practice, on the civil side, the criminal side, retired judges, and former members of the law enforcement community. In addition, we had tremendous amount of assistance from non-lawyers who work directly with individuals experiencing homeless and housing insecure. We took advantage of their expertise, and they provided valuable input. The names of all these individuals are in the report. We won't list them here, but we really could not have put together a report like this without the efforts of a large number of people with a tremendous amount of life experience and subject matter expertise. In addition, we heard from a number of speakers and consultants who have relevant expertise. They included the former acting commissioner of the New York City Division of Homelessness Services, the former New York City commissioner of the Department of Social Services, current law enforcement representatives from outside New York City, and the leaders of a host of nonprofit organizations addressing issues of homelessness and housing insecurity throughout the state. So we developed a bunch of recommendations. We appointed a number of subcommittees, each of which looked at a different aspect of this problem. And the subcommittees drafted their own reports and sets of recommendations that we combined into the large report for which we're seeking approval today. It's important to note that, again, while the report just scratches the surface, I'm going to go over each subject area that subcommittees examined and present just a handful of the recommendations. There are a lot more in the report. So I would encourage you, if there's an area in which you have a particular interest, to go back to the report and you can see the full scope of our recommendations. The first area we looked at was existing resources. I mean, what's out there now? What programs are addressing the needs of the housing insecure and the homeless? Which ones work? Which ones don't maybe work so well? One of the things we concluded was we needed greater coordination among the resources that are out there. We won't talk about all of these. You can read them for yourselves. One of the ones that may need some explanation is limiting the regulations tying emergency shelter access to eligibility for public benefits. People can lose their eligibility to public benefits for a variety of reasons, such as like failing to provide evidence that they're actively searching for a job, but they still may need emergency shelter. So one of our recommendations is to eliminate that requirement that you be eligible for public benefits in order to be eligible for shelter. Another recommendation is eliminating the requirement that individuals in the shelter system contribute a portion of any personal income if people have some personal income, in a lot of instances, they're required to contribute it to the shelter system. And this is actually, when you think about it, counterproductive, because keeping people in shelter is extraordinarily expensive. It's also disruptive. It's obviously not as conducive to health, both physical and mental, as having your own home. If they have some income, rather than contribute to the shelter system, that's money that could be used to help them actually find their own home. So we recommend eliminating that requirement. We also looked at the issue of whether the fact that there's a lack of sufficient affordable housing. It's one of the biggest problems, as I mentioned. New York, as I think as we all know, New York State has very high real estate and rental costs compared to the rest of the United States. Housing prices have been rising for years, and not at the same rate as any increase in incomes. New York State actually ranks third among U.S. states for the percentage of cost-burdened housing units. And that's a term that HUD uses, meaning that 30% or more of the household income goes to housing costs. We also have, I think, one of the highest percentages of what's called extremely cost-burdened housing units, where more than 50% of the whole household income goes to housing. So we have a number of recommendations, including incentivizing the creation and preservation of more housing units, particularly supportive housing units, which show great success in helping people get back on their feet. And that would include things like supporting local and statewide housing plans, using tax incentives to encourage the construction of more affordable housing, and supporting commercial to residential conversions. Some of the other recommendations include promoting accessory dwelling unit creation. And what those are, where you've got an existing lot and you put another small building on that same lot. So you create more housing density without necessarily changing the character of the community and drawing local opposition. We also looked at the barriers that exist to entry into the affordable housing that does exist. These barriers include things like source of income discrimination, a lack of housing that's accessible for people living with disabilities, difficulty in accessing supported housing, and complications due to immigration and prior interaction with the criminal justice system. One of our first recommendations here, as you can see, is developing a more individualized, case-by-case approach to approving housing for individuals under post-incarceration supervision. As many of you may know, when individuals are on parole or probation, they're subject to a variety of conditions. Some of those conditions can actually make it very hard to obtain or keep housing. And look, we're not saying you need to abolish these restrictions. Reasonable restrictions make a lot of sense, and the safety of the community should always be of paramount importance. But what we're saying is adopt a case-by-case approach. So if there are certain conditions that otherwise would be imposed that would limit the ability of an individual to get housing, but they're not necessary with respect to that particular individual, in particular for nonviolent crimes, then they shouldn't be imposed. We're advocating increasing enforcement of existing statutes prohibiting source of income distribution. So a number of individuals have vouchers, Section 8 vouchers, other support that provides a part of their rent, government-sponsored vouchers. A lot of times landlords refuse to take those tenants. Now that's illegal. There are laws against that already, but they're not really enforced, so it happens with great frequency. So our report has a number of recommendations as to ways that the enforcement of those existing laws can be increased so that people have housing vouchers or have an easier time finding housing. At the same time, we recommend providing additional resources to the administrative agencies that administer those housing voucher programs, and that's important for two reasons. I mean, there are a lot of paperwork, home inspections. It can be a complicated process. We want to give additional resources to those agencies so the approval process goes faster, so people are actually getting the vouchers and getting into homes quicker, but also so that landlords are paid quicker and more efficiency, so there's less of a hesitation on landlords to accept people whose rent is being paid partially or in whole by vouchers. We looked at the healthcare system. When you think about it, housing can be seen itself as a form of healthcare, and it should be viewed as a fundamental element of addressing healthcare issues for unhoused populations. Individuals experiencing homelessness face unique challenges when they're seeking healthcare. They're at increased risk of a whole wide range of health issues, and at the same time, they have much greater difficulty getting access to effective treatment. So we recommend better coordination of support services. A great example of that is the safe operations support teams, or SOS teams that are funded by the State Office of Mental Health. That program is a really good example of local coordination of providers to unsheltered individuals that are living with mental illness. We also recommend the provision of additional training to healthcare and housing placement personnel regarding the unique challenges faced by individuals and families facing homelessness, and providing transportation to medical care and pharmacies to get needed medications. This is of particular importance in rural and suburban areas. It's easier, obviously, in urban areas where there's a mass transit system for individuals experiencing homelessness to get to a doctor's appointment. If you're living in a rural area of the state and you don't have a car, it can be virtually impossible for you to get to a doctor without help. We looked at the criminal justice system. Right now, the criminal justice system is the primary way in which society interacts with individuals experiencing homelessness. But that's obviously not the most effective model, and in most cases, all it does is worsen the individual's problems and make it even harder for them to avoid homelessness in the future. There are some programs that have had success in addressing the needs of the unhoused population without imposing criminal sanctions. There are a variety of diversion and reentry programs out there. There's not a ton of data, so one of our recommendations, in addition to expanding those programs, is to look at those programs, examine them, collect the data, and see which ones are most effective and which ones are less effective. And then finally, we recommend the use of a coordinated approach among law enforcement and service providers in addressing situations involving individuals experiencing homelessness. There's a great example that's described in greater detail in our report, but I want to take just a few seconds to talk about it. Last year in Westchester County, the police were going to break up a homeless encampment by the Thruway. And typically in a lot of areas when this happens, the police basically just go in and throw everyone out. And the individuals lose what belongings they have, their lives are further disrupted, they lose, to the extent they have documentation that they need to obtain benefits or health care, they lose that. And usually within a couple of days, they just end up sleeping in some other public area. What happened in Westchester County last year was the police worked with the County Department of Community Mental Health and local service providers in advance. And the individuals in the encampment were connected with housing and various other services. They were given notice that this was going to happen, told when it was going to happen, and they're actually given an ability to take their belongings and store them with the local service provider. So as a result, a number of the individuals actually were able to find housing, and it was a much less disruptive program. So that's kind of a model that we think other communities should follow in addressing situations like this. We looked at the broader court system and the interaction between the court system and individuals that are housing insecure or experiencing homelessness. Foreclosures and eviction proceedings have increased dramatically since the various COVID-era moratoria expired. And eviction obviously has a devastating effect on individuals and families beyond just losing their homes. There are physical and mental health implications and a long-term effect on children in particular. Eviction proceedings or summary proceedings and tenants' rights are not always fully protected by the courts, and statistics show really a huge disparity in outcome between a situation where a tenant in an eviction proceeding is represented by counsel and when they have no lawyer and are trying to appear pro se. So we recommend an increase in the availability of counsel for individuals facing foreclosure or eviction. There's now a right to counsel in eviction proceedings in New York City that was passed a few years ago. It is dramatically decreased the number of evictions, the number of people losing their homes, but it suffers from lack of resources. So one of our recommendations is that more resources be provided to that program. And we also urge the consideration of a statewide right to counsel. In addition, there are some programs where local law schools have their students being trained to handle eviction proceedings and are working with local legal services organizations under the supervision of either a faculty member or one of the lawyers from the legal services organization to handle eviction proceedings. And those programs really are providing needed resources, and we recommend that they be expanded. I think I'm running low on time. I see Kathleen giving me the dirty look, so let me cover just a few more areas.
The light has gone on, yeah.
Yeah, okay. I'll speed it up. We looked at issues involving children and families. Had a bunch of recommendations there, including increasing the amount of resources devoted, in particular to children and families. One area of particular importance is people who survive domestic violence. There's a dearth of shelters for people who are victims of domestic violence. There are some in New York City, very few the rest of the state. And this is a problem that can't be solved by additional like rent assistance. It's not a financial problem. People often are losing their homes, not because they can't afford their apartment or their house, but because they can't live there safely. So we recommend increasing the number of shelters available to people in this situation. Two last areas. Veterans. Veterans have made a unique sacrifice to defend all of us and our freedoms. This is one area where this has been kind of a doom and gloom talk this morning, but I have some good news. This is an area where there's been a tremendous amount of success. The number of veterans experiencing homelessness has decreased dramatically from like the 2009-2010 time period up to today. And it's the direct result of the fact that the federal government dramatically increased the resources available to veterans, both in terms of housing and healthcare and other services. And as a result, we've seen the number of homeless veterans drop significantly. We have a number of recommendations set forth in much greater detail in our report as to ways that the number can be further reduced. Finally, we looked at rural areas and the issues unique to rural populations and recommend additional resources, but in particular, looking at ways to provide transportation. As I mentioned, that is a big issue for people experiencing homelessness in rural areas or unable to get access to services, including healthcare and other services, simply because they can't get there. So, in conclusion, there are really two takeaways. The first is resources matter. As I mentioned, the experience with veterans is a perfect example. The federal government invested a lot of money in services for veterans, and we've seen the number of homeless veterans decrease dramatically. Another example is in the 1980s, there was a surge in homelessness throughout the country, but in New York City in particular. And in 1986, the Koch administration announced the Housing New York Initiative that had a large capital investment in increasing affordable housing and earmarked a certain percentage to individuals experiencing homelessness. And that led to a really sharp decrease in the homeless population in New York City from 28,000 people in 1987 to 17,000 in 1990. Unfortunately, those numbers have since gone up, but it shows that when you invest resources and do so intelligently, you can have a real effect. And then the second takeaway is resources invested upstream are more effective. So in other words, it's better off to invest resources before people lose their homes than after they've become homeless, really for two reasons. One, they avoid the trauma and all the other effects of losing their home. At the second time, it's cheaper. So, for example, the average rent arrearage for households in New York State that are behind on their rent is $3,400. The average cost of keeping a family in shelter for a year is more than $84,000. So if you just look at the numbers, it makes sense to invest more resources upstream rather than when people have already lost their homes. So I just want to thank Meredith Dodd for her help. I want to thank our staff liaison, Mo Whitcomb, who was absolutely terrific. Matthew Pinello, who some of you know, some of you may not. He's the new State Bar Director of Government Relations, who did a great job reviewing and commenting on the report. And I want to thank Dick Lewis for his support and guidance. Thank you, everyone.
Thank you, Mr. Russell. May I have a motion to approve the report and the recommendations of the task force? Sounds like I had both just then. Is there a second? I heard a second. Is there any discussion? Yes, Past President Alcott.
Thank you, Madam Chair. Thank you for this very important and comprehensive report. You mentioned that perhaps contrary to popular belief, substance abuse and mental illness is not the sole cause of this problem, and I have no reason to dispute that. But it is certainly a cause. Anyone who walks in the streets of one of our cities knows that. And I wonder if you addressed, perhaps I overlooked it, I don't think I saw it, this issue. Anyone who has ever dealt with a person suffering from those afflictions of substance abuse or mental illness knows that an individual in that situation very often, almost always, loses the judgment to take care of herself or himself. That raises the question of course, providing the resources for such care, but also involuntary mandating of such care. That is an issue which, as lawyers, we are uniquely qualified to address. And I, share everyone's concern that the rights of individuals be protected, but I'm not sure that the right to spend days and nights on the streets in freezing temperatures is, I haven't found that in our Bill of Rights. So did you address that issue at all? Thank you.
Thank you. And Past President Alcott, you should be happy that I did not use the phrase NISBA once during my presentation. I mentioned at the beginning of my comments that this report, despite its length, really barely scratches the surface. So that's an issue that we scratched, and barely. We mentioned the need for additional resources. We did not get into the debate over the extent to which laws permitting people to be treated against their will. I know it's a controversial subject. I think there are legislation pending both at the state level and New York City level that would expand the ability of police and other service providers to have people committed. We did not dig into that issue. That's one of the many issues that we just could not address in this report.
Past President Levin-Wallach.
Thank you, Madam Chair. Past President Sherry Levin-Wallach. And I want to thank Past President Lewis for his foresight in creating this task force, and Bill for your work and the task force's work. This is an excellent report. I want to point out that in 2019, Past President Carson and myself co-chaired the task force on incarceration release planning and programs. And in that report, one of the recommendations, which was adopted by this House, which is therefore policy, was that we change the definition of homelessness because those individuals who are currently incarcerated are not considered homeless. They are considered to be housed. And when they're released from incarceration, they need to live basically in emergency shelter for some time before they can actually get to the point where they are determined to be homeless and therefore receive any services or housing regarding that. So I don't believe that that was addressed in this report, and if I am correct in that sense, I would ask for a friendly amendment that under Section 7, homelessness in the criminal justice parole system, you incorporate that current recommendation to, I understand it's still policy of this House, but really to heighten that, because as we know, oftentimes old reports get forgotten about, and I think that if we had that recommendation here, it would strengthen this report and then provide better opportunities for us to then lobby and move forward for reforms that would help change that definition and provide better opportunities for those individuals being released from incarceration.
Mr. Russell, I leave that to you. That is already the policy of the House.
So, as I mentioned, there's only so much detail we could get into in a 108-page report. There are a variety of issues where there are literally dozens, if not hundreds, of sub-issues that could be explored in greater detail. I mean, that is a prime example of one, Sherry, but it is, I don't want to say it's getting into the weeds because it is a very important issue, and we do refer to the need for kind of post-incarceration planning. We don't get into the specifics of the previous recommendation adopted by the House.
So I offered a friendly amendment that recommendation be incorporated into this report, and I'm asking if you're willing to accept that.
My understanding is that he has rejected the friendly amendment. Is that correct?
And my concern
Not
is...
in an unfriendly way, but...
No. And let me express my concern perhaps more articulately. If we do this, I suspect that I'm now going to start getting emails from 20 different people saying, well, you also didn't deal with this issue, you didn't deal with that issue. When I spoke about the work of the task force at the Joint President's Committee on Access to Justice, Committee on Legal Aid meeting yesterday, there were 3 or 4 people who got up and pointed to other areas that could have been in the report that weren't. So I agree it is an important issue, Sherry, and I agree that it is the policy of the association. My concern is that we open the floodgates, and instead of taking this report and following our plan now to send it to the governor's office, to the heads of the legislature, to OCA and other stakeholders, and use it to make some meaningful change, it's going to delay the report another, several months.
So then I would, if you're not accepting the friendly amendment, I would make a motion that that issue be incorporated into Section 7 of the report, Homelessness and the Criminal Justice Parole System, that the former recommendation that we change the definition of homelessness to a definition that determines that individuals who are incarcerated are in fact homeless. I would ask for that motion, and I move that motion before this House.
I'm going to hear from the other speakers before we take up your motion.
Good morning. Michael Marinaccio, 12th District Vice President, better known as the Bronx. Bill, I want to commend you on an excellent report, very important report. I particularly recommend everybody take a look at the section on education and the effect of homelessness on our children and their education. I have 2 daughters who teach in the inner city. They tell me all the time about the problems in educating young people who are in the shelter system in particular. Basics like adequate clothing, sufficient clothing, transportation, the disruption, being moved about, and also not having a place to actually adequately study. I know you've handled that in the report. I just want to recommend that everybody here take a look at that report. This is an issue, and it's an issue that's not going away, and it's going to affect our children for decades to come. Thank you, Bill. Great report.
Thank you, Mr. Marinaccio. We have someone with discussion or question or comment online. Mr. Forrester, are you with us? Going once? No? Okay. All right. Past President Levin-Wallach, I believe the amendment not accepted is therefore out of order. And so I don't believe that it's properly before us at this point, especially in light of the discussion. So I'm going to ask you to withdraw it.
I don't believe that the motion is out of order. I asked for a friendly amendment, it was rejected, so I'm now making a motion that it be incorporated into the report, and I'd like to see if there's a second for that motion.
So we need to see then the specific content of your motion.
Do you want me to state it again? Or do you like me to write it down?
Maybe we should write it down so people have the exact wording of what you're asking.
In the meantime, Mr. Forster emailed Taya. His question was, were there any landlords on the task force? There were no landlords, as far as I know, on the task force, but it's not a question we ask. I guess it is possible members of the task force had subtenants or something like that.
Okay, thank you for that point of information, Mr. Forrester.
And I would ask if the friendly amendment is not accepted by the House, if Sherry sends me a copy of the report, when we are reaching out to these other officials, we'll certainly include it in what we discuss with them.
Would that be acceptable to you, Ms. Levin-Wallach?
I didn't mean to interrupt your chain of thought. Sherry.
No, it's fine. I was trying to write out the motion. I feel, and I truly appreciate this, but I feel that this is an incredibly important point that we deal with every day with individuals who are incarcerated. And if people in our communities that are incarcerated continue to not be determined to be homeless, it will continue to exacerbate this situation, especially dealing with those individuals being released from prison. So I appreciate that, but I'm almost done writing my motion, which is not very difficult.
Okay, if you would keep it brief and finish that, then we'll take that up.
Okay, I can speak to the motion and then finish writing it.
Okay,
let's hear your very succinct.
Sure, let's hear your succinct motion.
Oh, there's another comment. Sorry.
Buying you some time? Yes.
Yeah.
Thank you.
Ian McLean, delegate from Trust and Estates Law section, and I rise in support of past President Cheryl Levin Wallach's motion, as well as the report, Bill, which is extraordinary. But it seems to me that this House voted on an extraordinary report a number of years ago about the horrible path from not showing up at school to getting arrested to ending up in prison of our juvenile population. And to the gentleman that spoke earlier, whose name I've just gone right out of my head, and I apologize, to his excellent point about the effect on education. So I think to be consistent with our prior policy decisions and the policy of this body, that we ought to seriously consider past President Cheryl Levin Wallach's amendment. I realize you're going to get this from many quarters. I thought of things while I was sitting there, but that's maybe not the place. But this is the only one, and it's this body, and you're reporting to this body, and it's your report to this body, not other organizations that you've reported to. So I'm encouraging to reconsider, but let me know when my time's up, Domenick, please.
You have 1 minute and 31 seconds.
Thank you, Madam Chair.
You got to speak to Kathleen.
I apologize. You ready? So I'm just thinking we are going to be consistent. We are going to be consistent here. We voted to examine that, to do what we could to stop that flow. Now this is not a new issue. I think we all probably remember the movie from the 70s, Fame. Now that was a very realistic movie, all right? But Fame, F-A-M-E, Fame, and if you haven't seen it, go see it. But there were homeless students at the High School of Performing Arts represented in that movie. Look where we've gone, 1990, 18,000 homeless. How many last year?
In New York City or New York State? New York State, I think it was 158,000.
How many of those were children who couldn't go to school regularly, get the support they needed, and came from homes where they were living literally ramen to ramen? That is why I think this motion should be entertained.
Thank you, Ian. Past President Levin Wallach, your motion.
So my motion is that this report incorporate in Section 7 the report of the Task Force on Incarceration Program and Planning's recommendation that the definition of homeless be changed so that individuals incarcerated are considered to be homeless.
So we're going to have a vote on the amendment first, and then depending on how that goes, then we will vote on the report. So all in favor of the proposed amendment, say aye, please. Aye. Any opposed?
Nay.
Online to split the tie?
Looks like it's getting incorporated. I did not think this would be
Online,
the
it's
controversial
20 to
motion.
18 in favor of the amendment. In the room, quite honestly, I couldn't discern, so I'm going to have people who voted in favor stand. And I'm going to have those folks sit and have those opposed stand. So thank you all. You can sit. The amendment passes. So now we're going to have a vote on the report as amended. All those in favor? Aye. All those opposed? Any abstentions? And we'll count online. And it passes online. Thank you very much.
Thank you very much, everyone.
Here. Our honoree is not present yet, and so we're going to move to the next item on the agenda. Yes, thank you. The report of the, we'll come back to that, the report of the Committee on Membership. Michelle Wildgrube, thank you. Michelle?
Good morning. Thank you all for getting up early after a wonderful gala. So good to see you all. So I'm here to give you a quick report on membership. I'm going to go over what we've got today with membership update, some takeaways, an update on the sections. We're going to talk a little bit about some additional marketing, and talk about social media, and then we'll talk about firm memberships. So the good news first, memberships are doing well. The revamped membership model launched on September 15th for new members, with renewals for existing members starting on October 1st. What that means is that people who were joining started on September 15th. If you were renewing, you started on January 1st. We currently have 35,807 members, which is fantastic. 68% of those are paid. Free members are 32%. So paid members are all of us. The new members are newly admitted attorneys and law students. So during the past 4 months, we've launched many campaigns over various platforms and channels to secure as many renewals as possible, and to introduce the newly revamped model to those who were never members in the past or who had dropped their membership. Overall, our membership has increased by 4.7% with over 35,000 members. We are really excited to report that we are tracking over $2 million in sales over this time last year. Much of that is due to the dues increase that you thankfully agreed to. And as you know, it was more than a decade without having a dues increase. So I also want to let you know that with membership drops taking place a little bit earlier this year, that's going to happen on January 31st, we will start a focus on the drops, and I'm hoping that none of you are in that pool and that you've all renewed your memberships. All right, so there are some changes in the membership. As you may recall from last meeting, we are now an anniversary-based membership. So if you were an existing member, you are going to be on a calendar year, but new members are coming in when they sign up. So if you were to join today on January 16th, your membership would expire on January 15th, 2026. This is important because we no longer have prorated memberships. That also accounts for some of the increase in revenue, because what would happen is if somebody joined in the latter half of the year, we were prorating their membership, they were maybe paying a third of or a quarter of the membership, and then they were had the opportunity to renew in January, and maybe they did or maybe they didn't renew. So now if you were joining in October, you would be paying for an entire year of or you would be joining for an entire year of membership, not just that portion. That's a very large revenue increase. We were doing the math yesterday, and if by making that small change, we went, if a membership was $275, for a partial or a quarter of a year, it might be $68,000 in revenue for the association. Now it's $275,000 in revenue. So really a good move, I think, and a lot more streamlined of an approach. All right, so we also are very pleased to announce that we have a lot of members agreeing to auto renewal and signing up for that. 600% increase, so absolutely amazing. And that's fantastic because, as you know, for all those subscriptions that you have at home, such as, you know, HBO, Disney Plus, Netflix, you are on auto renewal. You are now on auto renewal with the Bar Association, and I think that's a very good thing. It makes it a lot easier for our members and for our membership team. So that's a good thing. All right, for the sections are seeing an increase in membership because, as you probably know and recall, membership now includes 2 sections. Additional membership to sections is at a nominal fee. So we are seeing, again, really good, vibrant section membership. So what we've seen is that section membership overall has increased by 15%, and 27 out of 28 sections have seen an increase in their membership. So really just excellent for the sections. And I would also note that 50% of those sections are showing a double-digit percentage growth increase. So I do go back to prior reports to the House where, you know, we talked about that previously only 50% of our members belong to a section, and sometimes only one section. So now to have all of our members have access to 2 sections included with membership is, I just think, a great thing for the sections and a great thing for our members because, as you all know, section membership really is what gets people to get involved and remain members. So happy to report that. I'm going to talk for a second about firm membership. Firm membership is where we sign up an entire firm at the same time to become a member, to become members. It really helps, I think, the firms to organize their attorneys and make sure that they are signing up. And with that, the firm would receive discounted dues if they are paid all at once. So we do think that's a benefit, and we'd ask you to go back to your firms and not only check on your colleagues, please. Make sure that they are becoming members of the sections, but also investigate whether or not it might make sense for your firm to become, have a firm membership plan. And if you are interested, please check in with NYSBA's Member Resource Center, also known as the MRC. All right. So I want to talk about some of our activities as we wrap up. As you know, as I said earlier, we're about 4 to 5 months into the marketing campaign highlighting NYSBA. We have a new look. I like our new look. I think it's good. There's a lot of debate about it and discussion and input, and I think it's a good look. So you may have seen some of our ads. If you have seen our ads, now I'm going to ask you to like, comment, and share your reactions to our ads on social media. I know last time I asked you all to pull out your phones and to become friends of NYSBA. I really need you to do that. So if you could do that, I would really appreciate it. If you go to the Instagram page, for instance, today, in the stories on NYSBA, there is a story that you can go and visit our Membership Resource Center here at the annual meeting. So we have a lot of good information. I would love it if you could make it sort of a weekly practice to go and check out what's going on at NYSBA. And you don't have to just like the things that happened today. You could like things that happened yesterday and the day before. Catch yourself up. We just need a lot more likes on social media, and I'll tell you why. We are spending a lot of money on marketing. All of this is how you can help us have a better impact on the social media websites, and that's really important for us to attract new members and younger members. We are immensely popular on LinkedIn. We have a good number of followers on Instagram and Facebook, but we could definitely use more. The more that you like our posts, the more that you share our posts, the more that you comment on our posts, the more likely it is that that post will be shown in the feeds of your colleagues and of other people who are interested in the Bar Association. So it's really, really important that we have your support, and as ambassadors for the Bar Association, I would greatly appreciate it if we could see an uptick in numbers on that front. So hopefully not a lot of effort, but again, if you would just like, comment, and share, we'd really appreciate it. So that's my report.
Thank you so much, Michelle, for your leadership on this.
Michelle, could you just wait one question, Madam Chair?
Sure.
Peter Levy, elected delegate from the 10th.
Yes.
Based on looking at the numbers, so it appears that people are renewing that may not have been section members.
Correct.
That are not actually joining the section. So is any conscious effort being made to reach out and say,
Absolutely.
guess what, you have these,
yes.
do something about it?
So we have our lists, you may be
Okay.
familiar. So we are definitely reaching out to people who have not become members, who maybe, what we've noticed is that perhaps you have an administrative person at your firm who's signing everybody up. They're not aware of section membership, so they're not signing people up for memberships or letting them know that they even have the opportunity to have those two included section memberships. So we are looking at those lists, looking at the people who don't have section memberships and reaching out to them.
Good, okay,
So,
thank you.
Yes, thank you.
Thank you for raising that. That happened at my own law firm. People just were renewing through our administrative staff and didn't know that they didn't have sections before and that they should and can have them now. Thank you. Any other questions, comments, or discussion? That was an informational report, so there's no action necessary. Thank you very much.
Thank you.
So now I have the award winner, and I don't have my president. The dramatic entrance. Our next item is the presentation of the Ruth G. Schapiro Award to the Honorable Sylvia O. Hinds-Radix. That presentation will be made by President Domenick Napoletano.
I'm sorry to hold everyone up. I actually texted the judge. I said, where the hell are you? I have not only the honor, but the privilege of introducing our 2025 Ruth G. Schapiro Award recipient this morning. The award is named for our first chair of the Committee on Women in the Law, now called Women in Law Section, and recognizes exemplary achievements by an association member in addressing the concerns of women. Justice Sylvia Hinds-Radix, my friend for 40 years, is a trailblazer in her own right. She is the first Caribbean-born woman of color and second woman overall to serve as New York City's Corporation Counsel. As the city's chief legal officer, she was involved in all legal matters concerning the mayor's administration, which included overseeing the city's health and welfare of all those years ago, providing an important foundation that the city of New York needed to handle the COVID pandemic. Leaving her work in government, Justice Radix made her mark also as a jurist. Following a career in the courts of the city of New York, she spent 10 years on the bench as an Associate Justice of the Supreme Court Appellate Division, Second Department. In that time, she was instrumental in decisions affecting bankruptcy laws, commercial and federal litigation law, health and family law, and that's just to name a very few. That is what her resume says. But those who know her, as I do, and have had the privilege over all of those many years of knowing her, she is way much more than what's listed in her resume. She is a role model and a champion for women. In her nomination letter, Ira Watchman, president of the Women's Bar Association for the state of New York, says Justice Hinds-Radix embodies the spirit of Ruth Schapiro. In every workplace, from City Hall to the city courts and beyond, Justice Radix is looking out for women in not only her office, but throughout all of her endeavors, fighting hard to ensure that female employees are listened to, and valued foremost. She created a work environment where women have tools and encourage their a rise in their career. Watchman writes, Justice Hinds-Radix has a legion of women attorneys she has developed and encouraged, including me, not me. You, me. Outside of the workplace, Justice Hinds-Radix also cares deeply about helping the next generation by inspiring law students, children, families throughout her community. She started a second-time bar takers program that supported young lawyers and helped them successfully navigate through and passing for the second time the bar exam. In her community, she founded after-school tutoring programs, helping children from kindergarten through high school. Her impact on the legal profession, the community at large, and in the years to come makes her the most deserving recipient for this award. With great pride, I introduce you our 2025 Ruth G. Schapiro Award recipient, the Honorable Sylvia Hinds-Radix. Your Honor. Your Honor, it is with great love for you that I award you the Ruth G. Schapiro Award.
May I sit this on your Good morning, everybody. On the point of privilege, I hope you allow me to say something personal about our president, Dom. I call him Dom. Interestingly enough, he and I met when I had just graduated law school and started to work for District Council 37, one of the municipal labor unions. And we were opposing parties, and we became friends for over 40 years. I always respected his tenacity, his integrity, and his stride to ensure that everyone was treated fairly. We have such a class act. And, you know, I want to congratulate you, Mr. President, for last night's gala. I expected no less. Thank you for being you, but most of all, thank you for being my friend.
Thank you, Judge.
To the chair of the women's section of the New York State Bar Association, to the officers, members, bar leaders, special mention to Wabosny's president on a point of privilege, Mario Waxman, who's here with us, and to all here gathered, a pleasant good morning to all of you. I am indeed humbled to be here to accept an award named after Ruth Schapiro. This Memorial Ruth Schapiro Award was established in honor of the woman, law section's first year. And as Domenick said, she was a tax lawyer. She'd been appointed by President Carter to the Tax Court Nominating Commission in 1978, and she served on the panel until 1981, a trailblazer in her own right. past chairwoman of the State Bar Tax Section and Finance Committee from 1984 to 1989. She headed a special committee on women in the courts, which was set up by the State Bar. I tell you all of this about her because I want to enforce how humbled I am to be receiving an award in her name, because I think she was a bigger trailblazer than I am. I have been fortunate throughout my professional life to receive many awards, but this award is particularly special because of the organization and the section that is given this award. I have always and continue to be concerned about the rights of women and the voice of women in the legal profession. I am committed to ensuring that there is a voice for those amongst us who are voiceless. It is also important to me that you choose this day to celebrate me. I know as women, we tend to be our own toughest critics. We are harder on ourselves and each other than others are of us. We endorse the benign thoughts sometimes that some of us as women can't. Today, I would like to accept this award on the behalf of some of those women in my life who I believe always promoted me and believed that I could. I was born on an island of 166 square miles called Barbados. Yeah, Rihanna and I have something in common. It's not beyond my wildest dreams that I could have envisioned that I would be here today accepting this prestigious award. Those of you who know me and know of my background know that I became a lawyer on my mother's knee, the first female influence in my life. My mother listened to a radio show every day because, of course, she had no television. The show was called Portia Faces Life. It was a story of a female attorney who went to battle each day against a sea of men. She was always victorious. And that was when I decided, at about 8 years old, that I wanted to become a lawyer. I didn't know any lawyers. My mother, I don't even think, knew lawyers, but she was fascinated by this program. So throughout my legal career, I have been fortunate to be involved in women's organizations and bar associations, associations with women who know the value of our work and the contributions that we can make. I have heard questions asked of, why do we need a women's bar association? I believe that the developments over the past months have clearly demonstrated that not only do we need an organization, but we need to continue to strengthen the ones that we do have so that we do not lose the strides that we have made. There's one thing in addition that I would like to stress today. I would like to stress the need for us to be mentors to our young people, to ensure that our profession is always in good hands. We must prepare those who are coming after us to take over and be ready to hit the ground running. Mentorship is critical. And as I say that, there are some thank yous that I'd like to make. First, I'd like to thank our chapter chair from Brooklyn, the Honorable Cynthia Edwards, who's the president of the Brooklyn Bar Association, all of the women from the Brooklyn Bar Association who have supported me. I'd like to highlight Michelle Merman and Helene Blank, who are continuously and strongly always staunch supporters of what I do. But my gratitude today also goes to my daughter, Hinds-Radix Seaborough, who presented me for this award. I'm forever grateful. And I'm thankful to my daughter, Dr. Jeanette-Radix, who is here also today and is the mother of my 4-month grandson, whom, if she had brought him, would have been the youngest delegate in the room. But I earlier was speaking to our chair, and I was reflecting on how I got here. And I was saying to her that the question of why we need women's organizations was foremost in my mind last night as I was preparing these remarks. And I thought about an incident that occurred when I was a practicing attorney. I had just started, and I ran out to Staten Island on a case. And the judge who was sitting on the bench at the time, my opposing counsel was, of course, male. And I'm standing next to him, and he comes up, the case is set for trial. But today, counsel wants to have more discovery because he's not ready for trial. And I'm saying to the court, well, this case is set for trial, Judge. Discovery is over. And the judge, of course, continued to ignore me. And he kept on saying to me, ma'am, I'm listening to counsel. And it went on, and about 3 times I was called ma'am. And I started walking away from the bench. I don't know at that time where I got the gumption to do something like that. But I started walking away from the bench. And when I got somewhere around there, the judge said, I said, I'm not finished. And I started walking, and he looked and he said, counsel, I'm not finished. And I turned around and I said, Your Honor. And it was quite clear that there was a distinct recognition that as probably the female attorney at that bench, I was a ma'am. So I believe that is one of the reasons why, as women, we always have to make sure that we have organizations that promote our interest. But I also would like to thank those men who have made it possible for us as women to grow in this profession, because there are those like Domenick Napoletano, who always see us, and a lot of you in this room. So I thank you for what you've done for the women's section, for what you've done for women's lawyers, what you've done for female judges, and I hope that you will continue to inspire our young generation to take the places that you now hold. I thank you, and I thank you again for this distinguished honor. If I may, I have to recognize my Corporation Council family who showed up today, and the Corporation Council of the City of New York, who is here with us, Muriel Goodtrufant.
Thank you for those words, Judge, and congratulations. Our next item is the report of our President, Domenick Napoletano.
Madam Chair, are we on time? Okay. I need to know how long I could stand up here. So, once again, good morning, everyone. I hope you are all enjoying our annual meeting, the superlative CLE programs, these moving award ceremonies, and engaging in networking throughout this week. It is with great pleasure that we had, Associate Justice Stephen Breyer last night at our gala. Those of you who were there heard him in his fireside chat. Someone said it would have been much more impressive if there was actually a fireside log perhaps burning in the background, but I don't think the plaza would have allowed us to do that. But I found it very moving, inspirational, and engaging. The breadth and length of that man's knowledge was amazing. Our work here at the association office brings us together many times on different sides of the aisle. However, addressing the most pressing issues we face is where we find common ground. That is particularly what makes our annual meeting so special, as well as our association. We come together to collaborate on challenging issues because, in the words of the first president of this association, John K. Porter, we are strengthened by association with each other. The standard of professional integrity and honor is elevated by mutual intercourse and by the consciousness that our own status in determining by the enlightenment judgment of our brethren. I don't know how much truer those words resonate today, given all that we have been experiencing over the last few months. When I think of professional integrity, I am immediately drawn to past President Justin Vigdor, who recently passed at the age of 95 years. Justin served as our president in 1985 and 1986. He founded our senior law section, which is now called the 50-plus section, served on a dozen of not-for-profit boards, won a Lifetime Achievement Award from the New York Bar Foundation, worked as a lawyer for over 70 years, and was an icon in the Rochester community. He will be surely and dearly missed. Past President Vince Buzard has prepared a tribute to him, and I'm looking forward to hearing your reminiscence of your colleague, Vince. While Justin had the chance to be with us for a very long time, our esteemed colleague, Ariel Weinstock, was only attending his first House of Delegates meeting in Cooperstown in 2023, when he was unfortunately struck by a car. He died a year later from complications from his traumatic brain injury at the very young age of 42. I had the honor to present to his father, Ben, whom I met when I went to pay a Shiva call for Ariel at his home in Long Island yesterday afternoon at the Real Property section luncheon. And Ben paid a loving tribute to his son by showing us the progression of Ariel's life from a child to an adult and all of his accomplishments, and then finally to his unfortunate and untimely demise. It has been a pivotal 12 months for our association. Our new membership model launched successfully in September as a soft launch, and now officially in January. I am pleased that so many people have joined and that it is helping our sections in particular grow in both membership and, more importantly, in influence. I am also pleased that the new membership model makes our jobs more efficient, providing free and easy access to our renowned educational programs, our forums, and our publications, which are, in my opinion, quite outstanding and quite voluminous. Our task force and committees have been busy studying issues and working on reports. You heard Dr. Mary Beth Morrissey speak earlier about the opioid crisis task force that I created and that she heads, and I look forward to the final report from that task force sometime this year. The fine work that we're doing is only possible because of your selfishness, offering your time and talent to ensure that works stand out, as they have throughout this association's history. Our association is held, as I'm sure you know, in the highest regards by the courts, public officials, not only here in the state of New York, but throughout the country. And for one reason, and one reason only, the dedication, talent, and experience of its members. We are dedicated to revamp various laws. I've created a task force to do a deep dive in the CPLR, which hasn't been looked at since 1962, as well as the CPL, which has also not had a look at for quite some time, and sections and committees which I formed together are looking at those two bodies of law, which primarily do make up most of what we do. The upcoming year provides, again, an outstanding opportunity for the association to grow in its leadership. And again, I look forward to the reports that each of those task forces will be putting out. In Washington, our leaders will continue to engage Congress and the new presidential administration to implement our federal legislative priorities. They include adequate funding for the courts, the right to appointed counsel for immigrants during legal processes, which they do not have, the expansion on background checks for buyers of firearms, a ban on assault weapons, and the right of women to abortion services. Now, some of you may think, well, you know, these are very nice things, but I don't think they're going to pass. Well, I've been asked that question several times, and my answer is quite simple. We are not going to stifle our voice. Others may want to stifle us, but we are not going to do that for them. And the reason being that if we do that for them, then they win and we lose. So we're going to plod along, and we're going to continue to advocate for the things that we believe in, because I think it's only right and fair that we do so. In addition, we will continue to support eligibility periods for student loans relief for indigent legal service attorneys. We will continue to advocate for the repeal of the burdensome notary records recording requirements. On that note, I have the privilege of also knowing, as a colleague and as a client some years ago, the Secretary of State, Walter Mosley. I am trying to arrange, his mom has been ill, so it's been a little bit difficult in the last month or so, but I'm trying to arrange a meeting with him. And I will try my best to impress upon him that these notary requirements are just so burdensome on lawyers, staff of lawyers, you know, that they supervise, not just anyone. But for us, I think it's really a burden around our necks that we need to have loosened or just removed. The concept, I'm sure, as you know, for the recording of these notarizations stemmed from various notaries that were placed on transfer documents of deeds, and they felt, you know, there was some fraud going on there, so they wanted to avoid that, which is fine. But the penalty for any one of us who notarizes a fraudulent document is not simply the removal of the privilege to be a notary. It's our livelihood. We will face disciplinary charges and potentially suspension or disbarment or censure, and we don't really think that it's worth doing any of that, meaning being a fraud. So I will try to impress as best I can upon him the need for him to lift that requirement. For those of you who may not know, we were behind the bill in Albany to do exactly that. It passed both houses of the state legislature, but unfortunately when it went to the governor for her signature, she vetoed it. But that's past history. We are also aiming to address the backlog in the housing court when thousands of New Yorkers find themselves in litigation. The issues presented to both landlords and tenants in having their cases timely heard is not even close to being what it is today. I mean, you could wait months and I mean literally months, before you were in front of a housing court judge in the city of New York. Upstate areas are suffering perhaps not as great of a delay, but nonetheless a delay. And as we all know, justice delayed is not justice served. So we're going to try to cut through the morass of what's going on in the housing court, which I personally know. I go there. We are urging the legislature to establish the right to counsel for low-income tenants, because right now they are not represented, and the majority of those who are in housing court, 99% of landlords are represented by counsel. That representation figure is grossly disproportionate to tenants. As you heard, Bill Russell give his report on homelessness, which we've now adopted. I thought that was an outstanding report, and kudos to Bill and to the people on that committee, which my predecessor, Dick Lewis, had the foresight to put together. We are continuing our dialogue with the Office of Court Administration, and as I mentioned, some political leaders will be going up to Albany at the end of this month to lobby for the things that we feel are important, and hopefully those lobbying efforts will prove successful. We are continuing education for lawyers because we feel that that is a high priority. We don't want to be stagnant in what we do. We want to give everyone what we know to be the most accurate updates in the law. And so our CLE department has been actively putting that together, and I would encourage everyone, of course, to look at what is being offered. Looking ahead, we, in a year from now, will be celebrating our 150th anniversary. The venue for that will be the Plaza Hotel, as it was last night. As Kathleen will report later on about this, I believe. We hope that we get better sponsorship, better corporate sponsorships. Not that we were lacking so much in them this year, but we hope that we can start our efforts much earlier so we can have a much more successful gala next year. One of our first successful efforts, approximately in 1896, well, over 100 years ago, was through the formation of a partnership with law students and faculty to obtain legislation that establishes a uniform bar examination. Some 50 years later, at the end of World War II, the New York State Bar Association organized a corps of lawyers throughout the state to provide legal assistance to military members, or to military members. In another 50 years later, after the 9/11 terrorist attack on the World Trade Center, we were out in front to find resources for lawyers who had their offices shut down or destroyed in the wake of the terrorist attack. That happened during my year as president of the Brooklyn Bar, and we opened our doors to all of our colleagues to utilize the building at 123 Remsen Street for those who were displaced in their lower Manhattan offices. And so I'm sure that that type of was done also throughout the city. I'm sure NYCLA did their part. I'm sure that the city bar did their part. I know for a fact that NYCLA did their part because they were the hardest hit. They were right there on Vesey Street. While many other professions have had, their share of women leaders, we were truly blessed in having our first female president of this association, the late Marianne Sacramento Friedman, who passed last year after a complication of various illnesses. She was a friend to me. I met her late on in my involvement with the association, but I know that there are members here who knew her personally, especially Sharon Gersten from Buffalo and others, Kathleen as well, and I know that she is sorely missed. I'm going to end my remarks simply by asking the following of you. Like any association, at least those that I've been involved with, we have a team. In order to get to the finish line, the best way to get there, no matter what the issue is to work together as a team. This is not a team of one person. It is a collaborative team of all of you. If you find it impossible to do that, then that saddens me, because I don't know how else to act but to be a team player. But as I started by saying, there are divisions in families. This to me is a family. I would encourage all of you to put personal feelings aside. Everyone is entitled to them. I don't dismiss them. But if we're going to get things done in this association, like any other, we need to act together. And so that's my request, for everyone to please work together towards the better good of this association. And by doing it, I guarantee you that we can have another 150 years of success, and perhaps even more than that. So I thank you for allowing me the opportunity to stand before this podium and address you. I thank you again for allowing me to be your president for this year. And with that, I turn the program back over to our president-elect and chair, Kathleen.
Thank you, President Napoletano. Our next item on the agenda is a memorial for past president and dear friend, Justin Vigdor of Rochester. Vincent Buzard, past President Buzard.
Good morning. With our emphasis on access, we might want to consider having a railing on the stairs.
I endorse that.
Having fallen down one 2 years ago, and they're very handy. Anyway, it's a great honor for me, and it's extremely appropriate and fitting that we pay tribute to Justin Vigdor here today on January 17th, 2024, because it is the 38th anniversary of Justin addressing this very house in the city on January 17th, 1986. Justin Vigdor's life of service to his clients, to the profession, to the administration of justice, and his remarkable contributions to Rochester and the state, all flowed from Justin's view of what a lawyer does. His belief that such service is a noble tradition of the legal profession. But first, and all of that flowed from his being a lawyer. And Justin was an outstanding lawyer. We remember him for all of his good works, but he was first an outstanding lawyer. His ability and intellect to be a lawyer was demonstrated by his graduating magna cum laude from St. John and then obtaining a master's degree in corporate law from NYU. He started his service at the Pentagon trying cases, and then moved from the city to Rochester. And he had joined a middle-sized law firm at a time when many law firms in Rochester and around the country would not hire people of his religion. The people he worked with said he was a brilliant lawyer, that he had an intuition for determining how the law was to develop. And that interest continued for the rest of his career. He had a constant, and we didn't see this in all of our bar work, he had a constant desire to learn the law and to learn the development of the law, what happened, what was happening. And he held weekly meetings to go over the advance sheets of the previous week. Probably his level of enthusiasm for early morning meetings, reading advance sheets, was not met by, at the same level by his colleagues. Nor was his habit of calling people in to go over cases on Saturday. And he personally did not take vacations. He represented corporations in retail work and later in securities work and filings. And although he was developing his reputation as a corporate lawyer, he insisted in the first many years of his career to try a case, just to keep his trial skills current and to keep his skill level up. He made it a point of learning the businesses of his clients to better serve them. He became managing partner of his firm and was among the first to hire women at his firm, and, as a matter of innovation, the first firm in town to have computers. We may think that's an advantage or not. Naturally, flowing from his view of what a lawyer does, dictated that he become involved in the local bar association, the Monroe County Bar Association. And he eventually became president. And it was my pleasure, privilege really, to be on his board as secretary when he was president. And I could immediately striking value or ability was his ability to lead, to bring about consensus, letting everyone have their own say. But he was a pleasure, a real lesson in leadership. And I was also struck by the fact that he had such a receptivity to any idea that might serve the community or the profession. Very open to it. Naturally, also, out of that, he became active in the state bar, served as district vice president from Rochester, various committees, and became the president of the bar, this bar, in 1986. And all of his messages, or most of his messages, were about the duties of a lawyer to contribute to the community. He believed that lawyers there was a long tradition in the legal profession to contribute, and that lawyers had the particular skills of negotiation and advocacy and analysis to do that. And he went around the state advocating for the same value to be followed by other lawyers. He also was an advocate for advancing women in the law, which by 1986 had started, but was nowhere where it is today. But he was an advocate for that. He advocated for mandatory continuing education. He believed in the importance of staying current, and he thought all lawyers should do so. He worked to improve the condition of courthouses, and he also advocated vigorously for legal services. And he advocated for reorganization of the courts. His contributions to the law weren't limited, many as they were, to his Bar Association work, but he contributed as well as the first chair by appointment of Mario Cuomo to lead the Iola Fund. He founded, as has been referred to by the president, and was the first chair of the senior lawyers section. His interest in the development of the law continued as he served as commissioner of New York for the Uniform Laws Commission and on the executive committee of that organization. So that interest in the orderly of the development of his law continued throughout his career. In his role as, I should go back and say that he was chair of the senior lawyer section, the first. But more than that, he was a role model for those of us as we get older to not just hang it up, to let it go to Florida. I've earned it, all that. He continued, his love for the law was apparent by his continuing to practice the law until he passed away at 95. Now, his civic service was truly remarkable. He led the effort to establish a facility where a bunch of agencies, a group of agencies providing services with people with disabilities could all come to the same place. And that has been a thriving operation, which he also did the incorporation and was chair of and on the board really for his entire life. But it's a several-acre campus in Rochester and a great asset to the community, and also sort of echoes what he did in the legal community by raising the fund, conceiving of and raising the funds for putting all of legal services into one building, for which there was an ABA award. There was kind of there's a similarity there with his idea of grouping agencies for the convenience of the clients. In the 1980s, in his 80s, he was instrumental in founding the Fringe Festival and was the first chair of that and chaired it for 10 years, in which acts were brought, if you're familiar with Fringe festivals, acts are brought to town. 500 acts scattered around downtown Rochester where people can get near free or nearly free entertainment. It's the third largest Fringe festival in the country. I can't possibly list all of the organizations and awards as he's received, so I have to resort a little bit to statistics. Over his life, he was either the chair or director of 25 important civic institutions. He received over 15 awards for his contributions to Rochester and to his leadership. And a number of awards, including awards at this association, are fittingly named after him. And he was modest about it. I sat next to him at, the president referred to the Icon Awards, I sat next to him at that ceremony, and he kept sitting there saying, geez, I don't know why I'm getting this, why am I here, why are they giving this to me? Which was remarkable, given all that he had done. He had a favorite joke when he received an award, the short speech, long speech. The short speech was thank you, he said, and then the long speech was thank you very much. And he had a lot of practice using that joke. His empathy and human quality was also demonstrated by the devotion he gave to his wife Louise in her years of declining health. He would bring her to these meetings, and when he couldn't bring her here, still take her around. I would see them at Wegmans Grocery. But that level of devotion was his true measure. And so one might ask, how does a person do all that in one lifetime, a long lifetime? He did it because he believed it was his duty as a lawyer.
Thank you, Past President Buzard, for those lovely words.
Should we stand in a moment of silence or something?
Let's stand and have a moment of silence in honor and memory of Justin Vigdor, our past president.
Thank you.
Thank you. Next is the report of the Committee on Law, Youth, and Citizenship. Jay Worona.
Thank you so much. Good morning, everyone, and thank you for indulging us. We'll only be speaking for about 5 minutes or so, so hopefully this will be.
No, I'm just kidding.
Anyway, we have on the screen Gail, Ehrlich, and myself who have served as co-chairs for this important committee, and we also had Chris Riano, who was the third co-chair of this committee. As many of you know, on May 9th last year, we determined that it would be essential for the Bar Association to conduct a conference, a convocation on the importance of preserving everyone's understanding of civics in this country, given the fact that we're a polarized, fractured nation. Our president at the time, Dick Lewis, was the mastermind behind this particular effort and really ensured that we put this conference on in the greatest way that we could. We were graced with the presence, as many of you know, with Justice Sonia Sotomayor. We had Chief Judge Rowan Wilson, who joined us, along with national and state panels, exploring where we were as a nation and indeed as a state with respect to the understanding on the part of our students of where we are in government and where we are with respect to people's understanding of how we even absorb the news. Of course, you know that so many people in this country are media illiterate. And that's just simply not acceptable. It's not acceptable for any of us as citizens, but it's particularly not acceptable for us as attorneys who believe that the preservation of this particular world is based upon law. So we're very proud of that particular session. Gail and I presented to the House of Delegates in November. There was a report that was agreed upon. And again, this is just by background to give you information about what, of course, most of you already know. There's a report and recommendations of the New York State Bar Association's task force on civics convocation. That was approved, and it was determined that the Bar Association could not do this work alone. We needed to join hands with national groups, state groups that were already well underway in this particular work. So what's the point? Your executive director, Pam McDevitt, decided that it would be important just to give you a very abbreviated view of what we're going to be doing this year. Again, President Dick Lewis from last year had determined that this particular exercise was so successful. We involved students. We had legislative leaders and regulatory leaders really talking about how, as a state, we can come together and certainly do better than we've been doing. The work, of course, is not complete. So it has been determined that we're going to do another convocation. This year, it's going to be held at the Bar Center again, but on October 20th. And this particular event will be able to be live streamed as well. So hopefully we can have hundreds and hundreds of people joining us. The specifics of this event are not yet determined because we're still underway with this particular work. But where we are right now, I'm going to ask my co-chair, Gail Ehrlich, to just let you know exactly where we are right now, and we'll give you further reports as the year goes on. But it is our hope that October 20th, you'll all be able to join us for the second rendition of this very important work. Gail?
Thank you, Jay. Jay pretty much said everything. I just want to drill down a little bit so you get more specifics about what we're going to be focused on discussing. I'll start with a quote from the CEO of Cyber Safe Kids. The internet was designed by adults for adults, but a third of global users are children. We need media literacy to be core to the curriculum, embedded into different subjects through critical thinking. Another statistic from Common Sense Media: more than half of teens get their news from social media platforms like YouTube, Instagram, and TikTok, which, breaking news if you haven't already heard, the Supreme Court ruled against just this morning, so big changes coming there. A third of kids aged 10 to 17 trust online influencers more than they do newspapers. From a news literacy project survey in November of 24, 8 out of 10 teens say conspiracy theories come across their social media feed at least once a week, and 81% believe at least one of them. They are bombarded by misinformation and disinformation, and 94% want media literacy instruction in school, but only 39% report receiving it. So if we want to preserve the health of our democracy, we need media literacy education for our students. And it's not just what young people see and hear and read on their social media in terms of the news they get. It's also how they discuss it and their attitudes about sharing it. At last night's gala, Justice Breyer said that 8th graders are the ones we need to reach, to get them to find ways to agree and to find common ground. He said we'd be doing well to get them to 30% agreement. So, as last time, as Jay said, we're going to bring you speakers and panels from everyone who are stakeholders and experts in this arena: education professionals, lawyers. We have Shelley Mayer, who is chair of the State Education Committee in Albany. Chief Judge Wilson will be with us.
Senate Education Committee. Yeah.
I'm sorry, Senate Education Committee. And we're going to have students. Students are the ones we need to hear from. They will tell you what they're learning, what they need to learn, and you know, they're the future. We'll look at the national and the New York landscape, as Jay just said. We have our feelers out and invitations out. We are very hopeful that we will have a speaker who is a key player in the TikTok case. We're working on that now. So as Jay said also, it'll be live streamed and we hope you will all join us. Thanks.
Thank you, Jay and Gail. Your report is received with the thanks of the House.
Thank you.
Next, we're fortunate and honored to welcome an address by the Chief Judge of the State of New York. The Honorable Rowan Wilson is with us this morning. Thank you. I should have said all rise.
Oh, no, please don't. So I'm a big fan of the Socratic, well, good morning, everybody. I'm a big fan of the Socratic method. It has lots of virtues. It does have one drawback, which is it teaches lawyers not to sit in the first several rows of anything. And I see no matter how old you are, that's carried over. So I'll suffer with that. So good morning, everyone. It's an honor to be back with you at the House of Delegates meeting. And I thank President Napoletano and President-elect Sweet for inviting me to say a few words today. So we are here at a formative moment for our country and for the future of the state of New York and for the future of the system of justice that we cherish. High among the challenges we face is the public's growing lack of confidence in government. The decline in the public's trust in government, particularly the federal government, is not new. Popular trust in government has steadily declined throughout my entire lifetime. And recent years have seen that distrust reach near record levels. But a longer historical view provides some perspective. The United States, of course, was founded over very strong distrust and dislike for the British government. During the extensive debates over the ratification of the Constitution, the many arguments against ratification were rooted in distrust of government. As one pamphleteer who anonymized himself as a plebeian wrote in 1788, if adopted, the federal government, through the Constitution, the federal government would raise a few to the height of human greatness and wealth, while it will depress the many to the extreme of poverty and wretchedness. Over our 250-year history, distrust of government has been much more the norm than the exception. Before we get to the Great Depression, the Progressive Era and the short period between the 1810s and the nullification crisis were the only periods where the American public was not very politically polarized, and concomitantly, trust in government during those brief periods rose. When we do get to the Great Depression, though, what we find is the longest and most persistent period of trust in government. It arose during the Great Depression and it carried through World War II and persisted into the early Cold War. All of those events, which happened in sequence, demonstrated to the people the power of the federal government to do good and provided issues around which the public could broadly coalesce. Our view today that public trust in government has been declining steadily in my lifetime is colored by that frame of reference. Public opinion polls originated during that extended period of high trust in government. As historian Gary Wills has observed, distrust of government has been a constant in American history, sometimes sensible, sometimes hysterical, but always pronounced. That said, whether on the national, state, or local level, we are far better off, far stronger, and far better able to achieve the ends of government when distrust in government is lower. Tempers are cooler, and the distrust is in the form of healthy skepticism, not irrational or unthinking hysteria. When trust in government is low and based on sound bites and intolerance to hear and consider differing viewpoints, people are more likely to opt out of vital civic participation, like running for local office, volunteering in campaigns or other civic efforts, voting, or jury duty. As civic engagement declines, the points of interaction between the government and the public deteriorate, and a disconnect emerges between Americans and institutions founded to serve them. That type of distrust threatens the foundations of our democratic republic and the continued peaceful functioning of civil society. We in New York are not powerless to improve public confidence at home. Although public trust in federal institutions is on the decline, public trust in state judiciaries has been on the rise. A 2024 survey released last month by the National Center for State Courts found that nearly 2/3 of Americans express trust and confidence in America's state courts, a measure that has grown in 2 consecutive years. And the same survey found that a majority of Americans, 54%, gave state courts a positive job approval rating, a measure that has increased in each year since 2021. Now that's good news and a good starting point. Since I became Chief Judge in April of 2023, my leadership team and I have made public confidence in the courts a very high priority. New York can and should be a leader in ensuring public trust in government. And although a 63% rating is better than the 35% given to the federal courts, it would be somewhere between a D- and an F+ on a report card. It is not good enough. So I'd like to spend my time today sharing a few ways the unified court system has been working hard to improve public confidence in our justice system over the past year, as well as how we hope to continue our efforts in the year ahead. First, we have identified ambitious yet tangible efforts and ways to improve court operations, and we've partnered with the governor and the legislature to get the funding we need to make those improvements. The enacted 2025 budget included all of the funding sought by the judiciary, every single cent, and at the very last minute, the Assembly added another $8 million asking if we could expand some of our efforts, which we did. It was a huge uplift for the unified court system, which had been starved by more than a decade of near-flat budgets that represented declines in real dollars. The 2025 budget, which provided a 7.2% increase funding level over 2024, enabled long overdue pay increases for judges, paid parental leave for UCS judges and employees, significant investments in problem-solving courts and family courts, and the creation of new judgeships and support personnel. The New York State Bar Association lobbied very hard on our behalf, and your unwavering support for the courts has been instrumental in securing that funding. The governor and legislature understand the importance of the courts, and your efforts have helped inform them on innumerable topics. With your strong support, we achieved some important legislative measures, such as statewide e-filing and judicial security legislation. But even as to legislation that we did not achieve this last year, such as the elimination of the death gamble or the removal of restrictions on notaries, your support has been vital and truly appreciated. Our requested 2026 budget, which we published last month, continues our effort at deliberate, thoughtful investment in a more effective, transparent, and collaborative justice system. We are counting on your continued support to help us explain during the budget process the programmatic impact of our requested budget, including technology, infrastructure, and improvements directed at efficiency, security, and accessibility needs, the creation of new judgeships and additional support personnel to reduce backlogs, foster better decision-making, and improve access to the courts, and an increase in the juror per diem rate to adjust it for inflation from the last time it was set, February of 1998. The unifying theme running through every line of our budget request is ensuring our courts remain worthy of the people we serve. The improvements I just listed will help us cut through backlogs and better fulfill our mission of deciding cases efficiently and fairly in a way that allows the public to better understand and hopefully appreciate the role of courts. Second, we are working to grow public confidence in the unified court system by making physical improvements to our courthouses. Established in 2023, the Division of Court Modernization accomplished a staggering amount of improvements in 2024, only its second year in existence. By the end of last year, it had outfitted all of the New York City courtrooms and jury assembly rooms with assistive listening systems, partnered financially with the district attorney offices to modernize 36 criminal courtrooms across 5 counties, established a Western Regional Office to help facilitate ongoing sound system upgrades in courtrooms in Western New York, modernized older courtrooms with acoustic panels and sound blocking curtains that carefully maintained the integrity of the courtroom's historic characters, upgraded Wi-Fi bandwidth, and even repurposed some payphone booths to be smartphone charging stations. This is a very incomplete list of the division's accomplishments. I'll pause here to note that changing direction of a large institution takes time, And sometimes good solutions are not obvious and not easily implementable. One of the most intractable problems we face is that it is difficult for the public to have confidence in any institution when its facilities are in disrepair, which is the case with many of our courthouses. But neither the courts nor the state owns those buildings. The cities and counties do, and as many tenants know, it's often hard to get landlords to make even needed improvements, much less to construct new facilities when we've run out of space. The Division of Court Modernization's work is a bright spot amid that intractable area of difficulty for the courts. Third, we have worked to build deeper connections with the public, both by expanding the court's access to justice initiatives and by creating a new Office of Civic Engagement. So this year, our Office for Justice Initiatives, led by Deputy Chief Administrative Judge Edwina Richardson, hired 14 justice coordinators across the state, one for each district. The justice coordinators sit in each judicial district and are charged with learning the social access and equal justice histories in their jurisdictions, assessing available resources for court users, establishing local goals and objectives, implementing programs and initiatives to address identified gaps, evaluating the impact of initiatives, and reporting on ongoing and new initiatives for inclusion in quarterly reports. The justice coordinators also serve as liaisons with the Permanent Commission on Access to Justice to further statewide initiatives such as the implementation of implicit bias training, rural justice initiatives, mobile community courts, and legal education for court users, to name just a few. The beauty of our new organizational structure is that it allows our justice coordinators to understand and design initiatives to meet the unique needs of the local judicial district in which they sit. This past summer, we also created the Office of Civic Engagement and hired a statewide civics coordinator, Zenith Taylor, who has been hard at work. In October, Ms. Taylor partnered with the New York State Bar Association, as well as 15 other bar associations, to launch our first ever Constitution Day essay contest for high school students. The aim of the competition was to energize high schoolers across the state to critically examine the principles set forth in our nation's Constitution. 227 students sent in submissions, all of whom will receive a certificate of participation and a pocket-sized U.S. Constitution. In the coming weeks, we will announce the first, second, and third place winning essays and feature them on the UCS website. And for those of you who were at the gala yesterday and heard Justice Breyer tell us that our target audience is young people, 7th and 8th graders, he said, I think we can stretch that a little bit up perhaps to high schoolers, but that's where we have to build the foundation for civics that has been lacking in this country for the last 30 or 40 years. 2 days ago on Dr. Martin Luther King's birthday, we organized a Service Day event in his name in which law students provided legal assistance to court users in initiating an uncontested divorce. Run in participation with the Franklin H. Williams Commission, Queens County Supreme Court Civil Term, and St. John's Law School, the program was designed to engage law students and promote community service. A similar day of service in Erie County, run in partnership with the University of Buffalo Law School, is planned for later this month. And on the topics of civics, which you just heard from Jay and Gail, a highlight for me of 2024 was my participation in the New York State Bar Association's first Civics Convocation this past May. It brought together, as you heard, Justice Sotomayor, young people and expert speakers from education and from law to discuss problems and solutions to our nation's crisis in civics education. Justice Sotomayor, some of you may know, has actually written 2 children's books, really for not even 7th and 8th graders, but more for sort of 2nd, 3rd, 4th graders, both in English and Spanish, and I highly recommend them. I have a copy of one of them in my bookshelf. And as a final example, we are proactively engaging directly with the public to boost civic understanding and engagement with the courts and with government generally. 2 summers ago, for the first time ever, the court system ran a summer internship program for high school and college students. We hired and paid 100 student interns who worked in courthouses across the state. We expanded to 150 student interns last summer and will expand it further next summer. The application posting is now on the UCS website. The program will run July 7th through August 13 and pay $18 an hour. and we're accepting applications through January 31, and I encourage you, talk to some young people you know who might be interested and otherwise ignorant of what courts do. I had actually never met a lawyer until I was in college. It was Archibald Cox, and had never met a judge until I was in law school. In addition, for 13 days this past summer, we set up a booth at the New York State Fair, staffed with judges, attorneys, court officers, and other court personnel who talked with every passerby from the public about what we do, and we tried to build confidence in the unified court system and explain who we are, that we're people trying to do a good job as public servants. Court leadership nixed my suggestion for a dunk-a-judge tank, but more than 200 court employees spoke to more than 22,000 fairgoers at our booth, and about 640 members of the public volunteered for jury duty, and 730 registered to take the exam to become court officers. So as I look forward to the year ahead, one thing I greatly look forward to is our continued partnership with the membership of the New York State Bar Association. Presidents Lewis and Napoletano have been, during my term as chief, wonderful partners in working to enhance the public's understanding of and confidence in our courts. And I'm certain that President-elect Sweet will continue the Bar Association's strong and tireless efforts. She and President Napoletano have met with me regularly over the past 8 months and will continue to do so during the rest of President Napoletano's term. I'm sure that President Sweet will continue to do so during the rest of her term, once it starts. And they know that my door is always open to them. I'm a phone call away or a video chat away or an email away if they need me outside of our scheduled meetings. I want to conclude by asking all of you and the membership generally a favor. When someone asks you about New York's courts, please don't just say the courts decide cases. Say, too, that the people of the unified court system are here to help not just with legal problems, but with education, with employment, with community outreach, with infrastructure, with legislation, but most of all, with innovation, compassion, and above all, justice. Thank you, and here's to the year ahead.
Thank you so much. Thank you so much, Judge Wilson. We look forward to continuing to work closely with you and OCA in the year ahead. Next is the report and recommendations of the local and state government law section, ethics rules for government entities, and Stephen Leventhal will be presenting.
Thank you. Hello, everyone. I am so pleased to have the honor of following the Chief Judge today because the proposal of the local and state government law section that I am here to present is aimed directly at the issue just addressed by the Chief Judge, and that is the need to inspire public confidence in government. I was appointed in 1990 as a member of the Nassau County Board of Ethics, and I quickly realized that I knew nothing. So I joined this association's ethics committee of the local and state government law section and met an attorney named Mark Davies, who at the time was the executive director of the New York City Conflict of Interest Board and had previously been the executive director of the Temporary State Commission on Local Government Ethics. And lo and behold, I learned that there was a statute that imposed a statewide code of conduct for the officers and employees of local municipalities. There was a body of common law establishing principles of government ethics. There were opinions of the Attorney General, the Comptroller, treatises, and learned treatises and publications also addressing issues of local government ethics. Since that time, I've spent 35 years concentrating my practice in this area. I currently am ethics counsel to 2 counties, 5 towns, a city, 2 villages. I lecture and write frequently on this subject throughout the state. And I can tell you that throughout the state, ignorance abounds. The temporary state commission on local government ethics that I mentioned, Mark Davies having been the director of, sunset out of existence. So by 1990, when I met Mark, it was already, it no longer existed. That was the only statewide agency that had oversight authority over local municipal ethics. That, in the absence of that agency, issue that our section has repeatedly drawn attention to, in the absence of that agency, the responsibility to oversee local government ethics has devolved upon the ethics boards established by local municipalities. And I can tell you that there are very few municipalities in the state of New York that train the members of their local boards of ethics in the principles of government ethics. So there are at least 3 types of bad local ethics boards. There's the ethics board that never meets. There's the ethics board that is politically motivated. There's the ethics board whose members don't understand their mission. So we have made a proposal, the local and state government law section, that is grounded in a philosophy that is based upon experience, it's supported by logic, and that is that the overwhelming majority of government officers and employees are honest and truly intend and wish to do the right thing, and will do the right thing if they're helped to understand what the rules are. So our proposal is not rooted in morality. It takes a rules-based approach to the subject, and it believes that if people are educated, that the ethics in government will improve. And if ethics in government improves, of course, so will public confidence. We're not really aimed at addressing evildoers. Evildoers will do evil, rather. What we're more interested in is helping honest officers and employees of local municipalities to avoid unintended ethics violations before they occur. So our proposal is to amend Article 18 of the New York General Municipal Law, that is that statewide code of conduct that I mentioned a few moments ago, amend that statute to incorporate a training requirement for the members of local ethics boards that is identical to the training requirement that is also imposed by state law on the members of local land use boards. In approximately 2000, when the village law, the town law, the city law were all amended to incorporate that training requirement for the members of land use boards, the statement of legislative purpose said that the reason they were doing it was because of the importance of the decisions made by those boards to local municipalities and their residents. Well, I posit that the decisions made by local boards of ethics and the duties that they discharge are just as important to the residents of those municipalities and the municipalities themselves as the decisions made by land use boards. So this requirement, which would exactly track the educational requirement already existing for members of land use boards, would not constitute an unfunded mandate, because local municipalities can opt out. They can not only opt out, they can also design their own programs that would satisfy the requirement. They can select programs that would satisfy the requirement. And no action by a local board of ethics would be invalidated because a member of a local ethics board failed to comply with the training requirement. Rather, the consequence of a failure to comply would be that that non-complying member would be ineligible for reappointment. And finally, as is the case with Article 18 of the General Municipal Law itself, the City of New York is excluded. City of New York has despite what you might think from newspaper accounts, the ethics program of the City of New York is the model for the world. So this proposal has the unanimous support of the Executive Committee. It has the unanimous support of the Sections Caucus. I sincerely believe that the only effective ethics reform is education, and I hope that you will support this proposal. Thank you.
Thank you very much, Mr. Leventhal. May I have a motion? Oh, yes, may I have a motion to approve the report and recommendations of the local and state government law section? Second? Is there any question, discussion online? Don't see anyone in the room. All right. There is no question online, correct? There is, there isn't? Okay, thank you. So we will now take a vote. All those in favor of the report and recommendations, say aye. Aye. Any opposed, say nay. Online? 100%. Congratulations and thank you very much. Next is the report and recommendations of the Committee on Attorney Professionalism. Robert Kanowitz, Andrew Oranger, and J.C. Mazzola.
Thank you. I'm Robert Kanowitz. This is my colleague J.C. Mazzola, and Drew Oranger is online. And we're here to report to you and seek approval on a report that we have put together, which was approved yesterday by the Executive Committee, on the consequences of attorney representation and principally how the public should categorize and view what attorneys have done in the past when attorneys are up for nomination or election for public service. As almost everybody knows, this particular subject matter is often conducted in sound bites on newspapers and TV. You know, how can you vote for him because he did thus and such, or you must vote for her because she did so and so in the past. And the purpose of this report is to systematize, not to make any particular recommendations, not to take any substantive positions, but to systematize the kinds of considerations, the kinds of contexts that hopefully members of the public, and this goes with the remarks that the Chief Judge made about civics education, hopefully this will serve a civics purpose as well, that members of the public will understand, probably first and foremost, that one of the roles of lawyers is to represent people who are not very popular, sometimes people who are despised. And yet, despite that, that doesn't necessarily say something about the character of the lawyer herself or himself. And going beyond that, how did someone represent, when was it, what were the choices, what was done, and so on and so forth. As we've done in the past with a number of reports from the Committee on Attorney Professionalism, as I mentioned before, the goal is not to take substantive positions, not to say this is good, this is bad, but to lay out a framework, a bunch of factors that people can consider, and hopefully this will serve an educational purpose for the public, and ultimately also serves as something of a guidepost for lawyers themselves in terms of thinking, okay, I'm going to do this now, how might this or might this not affect me in the future? That's the nature of the report. I think it's been disseminated. It was, as I said, it was approved yesterday by the Executive Committee, and I think my colleague Drew Oranger may have a few more things to say as well.
Yes, I just want to underscore just a couple of points here. This has evolved, this report has evolved over years, literally years, and as it's evolved, we've put more and more emphasis on what Robert was just saying, which is the concern that the public just doesn't understand that it is the role and responsibility of a lawyer to make sure that people have representation even when those people may not be the best of people. In working this through over the years, we got this to the point where the CAP was unanimously in favor of the report, which I think was a tremendous accomplishment. And then just yesterday, we saw what we perceived anyway to be resounding support in the executive committee. So hats off to Robert for carrying this forward, to really spearheading it and leading it and not giving up. And we think we've got something here that is going to be helpful to attorneys as they, try to understand, the twists and turns of what they themselves are doing as they represent various clients, but really more to focus the public on the fact that attorneys have a job to do and that the clients are entitled to representation really regardless of who they are. So those were my thoughts.
And I should mention one other thing that we've talked about, and this is something that we consider aspirational, but not too far off. We're hoping that, as I said before, this will help in civics education and bring more awareness to this, and hopefully it's also a starting point. As people begin to understand these kinds of things, they'll understand better, in a broad sense, what the role of the legal profession is. It'll eliminate some uncertainties, it'll eliminate some confusion, and hopefully will redound to the benefit of the entire profession.
Thank you very much, gentlemen. At its meeting yesterday, as was mentioned, the Executive Committee endorsed and recommended adoption of the report. May I have a motion to approve the report?
So moved.
Is there any discussion? Past President Alcott.
Thank you, Madam Chair. I commend the committee for addressing this very important subject, but I have to say I was disappointed in your report. A lawyer has an absolute obligation to represent unpopular clients, full stop, and the public should not judge the lawyer on the basis of the alleged misconduct of the client. A report by our association should give full-throated endorsement of that principle, but I found this report to be ambivalent and to say it depends on the circumstances. I don't think it does. The most famous example, which you allude to in your report, is when John Adams, historically 250 years ago, represented the British soldiers who fired on Americans at the Boston Massacre. Now, talk about unpopular clients, and Adams said that this was, quoting him now, one of the best pieces of service I ever rendered to my country. Well, that should be the exemplar, I think, that any report of ours sets forth for the Republic. I mean, a criminal defense lawyer will represent only people who are accused of misconduct. Mother Teresa does not need a criminal defense lawyer. And we should make that clear in my view. Usually it's a member of the public, as you said, who comes to the lawyer and said, how can you represent someone who's guilty? And we have to try to educate him. I don't think this report did a good enough job in doing that because of all the uncertainties and the questions. The New York code or ethical criteria say that a lawyer, I'm quoting now, is required to accept a fair share of tendered employment, which may be unattractive both to the lawyer and the bar generally. And when the lawyer is appointed as counsel to represent a criminal defendant, the lawyer may not refuse to accept that representation except for a compelling
reason. And the code expressly says that a compelling reason does not include the repugnance of the subject matter, the repugnance of the person, or your belief that the client is guilty of the crime charged. That's not a reason that you're permitted to use to refuse the assignment. Now,
Mr. Elka, please wrap up your remarks.
let me just take one more second. I think I'm the only speaker. There's one exception that's very important that proves the significance here, and that is if the representation is so repugnant that you cannot effectively represent the client. Now, what does that teach us? It teaches that the whole purpose of this structure is to protect the accused, protect the client, protect the system, not to protect the sensibilities of the lawyer or the public. So I don't want to stand in the way of your good work. I would love to have you take another crack at this and give a more full-throated endorsement of these principles. Thank you.
Would you care to respond? Or?
Only that, as Drew Oringer mentioned, this is the product not of overnight thought. This has been, I think we started working on this probably about 7 years ago. It's gone through a number of iterations, and the motivating factor is not, and I think a fair reading of the report does not suggest that lawyers should not represent clients because clients are repugnant. The lean of the report, if I can call it that, does lean in that direction and does lean towards saying lawyers should do this kind of thing. But it also is designed to educate the public, and with all due respect to everybody here, the mores of the court of public opinion are different, unfortunately, than the mores to which we hold ourselves. And this report, we think, strikes, I won't even call it an appropriate balance. We think this report strikes a directive to the public to think about this and to understand that lawyers do choose to represent unpopular people. We also know that some lawyers choose not to. And notwithstanding that if a court calls you up and says you must represent so-and-so, you can't decline it, there are many, many, many opportunities where lawyers do make decisions. How is this going to affect me? How is this going to affect my workload? How is this going to affect my reputation? Whatever it might be. We produced a report that we think, and I will use the word, strikes the appropriate balance, leaning toward educating the public that one of the things that lawyers do, and in which we all take pride, is representing clients and causes that are not necessarily the most popular ones and often are very unpopular.
Thank you.
And I would just add very, very briefly, may I add very, very briefly?
Yes, of course.
Okay, just very, very briefly, that we did strive for consensus. Consensus was not easy to attain for this report. The unanimity in the CAP, in the Committee on Attorney Professionalism was hard fought, was fought hard for. And then again, I just want to make the brief comment that our perception, or my perception, of the response in the Executive Committee was that the speakers that I heard in the Executive Committee felt that the report did accomplish the things that the comments indicated were not accomplished. So we took great pride in that. We were pleased about that. We certainly would love to have unanimity. It sounds like we will get at least something short of that, but that is what we strove for. And until now, the indications were that we had gotten to the right place.
I see one more speaker coming to the microphone. Mr. Cohen.
Thank you. My name is David Cohen. I'm the Vice President from the 11th Judicial District. I'm a member of the Executive Committee, a past chair of the Criminal Justice Section, and probably the only person in this room who's been subjected to what this report goes about, because I've been a lifelong, criminal defense attorney, and I was an elected official. I was a member of the New York State Assembly in the early 80s. And while I agree completely with past President Alcott, we need to start the conversation about this and get this out in the public, that it is not something that you hold against a lawyer because he or she represents unpopular beliefs. I have never represented someone who's popular. My entire practice has been representing people accused of crimes, some very, very heinous crimes, some very, very serious crimes. And so the public, forget about what, John Adams said a very nice thing, and that's theoretical, but practically speaking, the public has to understand that what we do is defending the Constitution more than defending a client, and it's defending the system more than defending a client. And so this is a very important first step. I hope that we'll go further, but I rise and thank CAPS for this report and urge its adoption. Thank you.
Thank you. Is there any more discussion? Mr. Marinaccio.
Thank you. Once again, Michael Marinaccio from the 12th District. I'll just be very brief. David's not the only one. I've represented very unpopular people in the past and actually was subjected to the types of accusations that you're talking about when I was about to assume the helm of the Bronx County Bar Association. In my case, my association came to my defense. Leaders of the Bronx Bar contacted the press, talked publicly about the accusations that were made against me based upon individuals that I had represented in the past. So what I urge our association to do is to look upon this report as a resource for our members if they're placed in the unfortunate position that they are accused of being, in effect, their clients. Thank you. Good report.
Thank you. Seeing no, there is one more hand in the chat. Nope. Okay, great. Then we're going to proceed to a vote. All in favor, please, of the report and recommendations, please say aye. Aye. All those opposed say nay. Any abstentions? And how are we doing online? The motion carries. The report is adopted. Thank you, gentlemen.
Thank you.
Thank you so much.
My script says there are no applicable administrative items. I'm sure that breaks everyone's heart. So, moving on to new business. Seeing none, I will first request that all of you practice your Go Bills chant. All together now.
Go Bills!
And now we can have a motion to adjourn.
So moved.
All in favor?
Aye.
Any opposed? We stand adjourned. The next meeting is Saturday, April 5th, 2025 at the Bar Center. Thank you.